to our session as we resume today and continue. I want to welcome the members of the committee present here at M46, as well as on the virtual platform. I want to welcome the public protector at M46 here. I want to welcome and recognize the evidence leaders here at M46, the entire support staff of the committee, members of the media, and members of the public in their various platforms. Thank you very much. We are today resuming with our reading of evidence done by Advocate Bauer, as we started yesterday. Before I continue, just want to check, Mr. Cornelius from Merwe, are you on the platform?
Good morning, Chair. Yes, I am. Good morning to you and the members and the public protector and the team. Thank you.
You remain under oath. Thank you.
Thank you, Chair.
So it means our system is working. Before I go to Advocate Bauer to continue, I have just received an email from the public protector. Just a few minutes before we started. And I'm going to ask her to just indicate the issues she's raising in the email. Public protector, I hand over to you.
Thank you, Chairperson. Honorable members, evidence leaders. I would like to just confirm and explain my position on the current proceedings for the record, Chairperson. In the letter to you, which I read out yesterday, I made a specific request that if you decide to proceed in the absence of my legal representatives of choice, you must give me reasons. That has not been done. I'm still waiting for that. My attorney yesterday asked to be excused since he had other commitments. You refused to excuse him, even though he had finished his assistance to the committee. When it became clear that you had ruled to continue without representation, I asked to be excused and I was no longer participating. You refused as well to let me go. So I sat against my will and I felt as if I'm just sitting here as a hostage. So I said yesterday again, Chairperson, explaining that I feel that it's sitting here as if, and I'm just giving an example that as if I'm in an abusive relationship, I'm just told just to sit and listen and not view my issues. Yesterday, Mr. Mileham indicated that I'm disingenuous. And I think that to me, I felt it's not, well, I'm not a member of parliament. You said it's not unparliamentary, but disingenuous is being dishonest. And I think I was expecting you, Chairperson, to request him to withdraw that. So allow me today, again, if you still insist to proceed, you can proceed, but I'm still expecting the reasons, and I still feel that sitting here, I wouldn't be doing anything. And again, I want to register that there was no scheduled sitting of the committee today until you made an announcement to that effect yesterday afternoon. So we were only informed about the sitting on the 1st of November, actually, because I was coming just to report. And there's no program which says the committee is sitting today. So I think I just wanted to register that, Chairperson. Thank you.
Thank you, Public Protector, Advocate Kwabane, for placing those issues on the record. Would have just indicated that you will receive your letter a few minutes ago. Let me just say this so that we remain to be clear. I'm not going to repeat the ruling I made yesterday. The ruling of yesterday stands. There's no rediscussion and reopening of that ruling. And that ruling was that we as we have started, we'll continue leading evidence as Mr. Van der Merwe did, led by Advocate Bauer. Today, we're going to be continuing to complete that. You would have asked to be excused, and I denied that. I declined that. It is in your best interest, for your own benefit, to be here as the Public Protector South Africa, who accounts to the National Assembly. This is the work of the National Assembly. It's an exercise in accountability. I still maintain that you're going to be given no leave of absence for these proceedings as a head of Chapter 9 institution accounting to this body. And so that ruling is repeated today, that you will not be excused participating and sitting in this hearing as we lead evidence. In relation to the attorney of record, the CNR attorneys, and I would have indicated yesterday as well, they were not given any leave of absence, no excused, and they were with us until 1 o'clock. I expect them to be here today. And again today, there is no leave of absence given to them. They are not excused. If they're absent today, there would have to be a reason why and they must have to explain why they will be absent. And so that takes care, for example, and I would have communicated this even after the committee, that they were here as your attorney of record, and therefore, as the Constitutional Court would have indicated, they are your legal representatives and practitioners. The issue is not having a senior counsel here in order for you to fulfill that your legal reps are here. They were here. I expect them to be here today. If they take a particular choice not to be here, that will have to be explained. So today there's an expectation that Sianeho is on the platform as we concluded the meeting yesterday. And so the reason would have been given that because everything else that would have started yesterday, even the leading of evidence, is already on record. And when there's going to be cross-examination, that will be available, as would show the program later on as to when that would happen. And so we are under no obligation to pause and postpone this. There is no legal impediment for us not to proceed with our hearing. So I want to urge you, I would have attended to the matter of the disingenuous statement, and I indicated that I would not ask a member to withdraw that which I still maintain. It was not unparliamentary to say that. I would have spoken to you to refrain from making an example that of the GBV example, that you are here almost like in an abusive relationship. And I addressed that as well. So I don't want to repeat, as I indicated, the kind of ruling that I made yesterday. So I just want to remain focused on that and repeat that ruling stands. And as of today, there's nothing of a new evidence in front of me as a chair that then indicates that we need to revisit that and therefore take a different decision. So thank you for that. And I think that's my ruling, that's where it will stand, so that we're able to to have the witness on stand continuing. The plan is that that witness must conclude today. Advocate Bauer.
Good morning, Chair. Good morning, everybody. Mr. van der Merwe, are you? I think he is with us on the platform, Chair.
Good morning again, Chair, and members and advocate. Is I'm trying to testify without the aid of the earphones, and I just wanted to confirm if the audibility has improved as a first point of order.
We can hear you.
Can you hear me? Thank you, Chair.
Properly. We will always remind you when you fade or when you look the other way. Maybe just before you proceed, Ms. Ibrahim, something you want to raise?
Thank you, Chair. I just wanted to remind Mr. van der Merwe that he is still under oath and that you will continue to be under oath, even if there is a delay in the process for cross-examination and questions by members. Thank you, Chair.
You got that?
Thank you. Yes, thank you, Chair.
Thank you. Advocate Bauer, I'm asking you to proceed. You started yesterday with some very long pauses. I hope that you'll get rid of them today. Proceed.
We have tried to sort out our electronics. So, good morning, Mr. van der Merwe. If I can just take a few minutes to recap.
Yes, thank you, Chair. There are also 3 issues that I just want to clarify of something that occurred to me on the evidence of yesterday, if you will allow me, Chair.
Sure, there's also one mistake I made, which I'll fix, but you can go first, Mr. van der Merwe.
Yeah, you asked me to confirm the date of my appointment as Senior Manager Legal Services. And that was actually the 1st of August this year, 2022, following a recruitment process that started well earlier in the year. The second issue was the invoice that was an impression that it was with the, there were about 13 bundles of documents that we couriered up and down between the committee and our office. But the invoice that we were reflecting yesterday with the yellow markings was actually retrieved from the Mimecast cloud service and not as part of that document. And then, sorry, the third issue was you asked me about whether the public protector ever engaged me on Mr. Ngubeni. And I said, no, not in the context of this work, the project that was, and the work that was facilitated with Mr. Professor Siepe and Kim Haller. But there was a situation afterwards, a while back, when the PP asked us, me and a number of colleagues, to get a file that were of a matter that was handled in Advocate Madonsela's time. It led to a report that dealt with the appointment of Mr. Ngubeni then as a special advisor, and it was under the goals of something about a fugitive from justice. And the PP asked us to get the actual file, and it was quite urgent. And when we couldn't file, I asked for details, and then it came out that it related to Mr. Ngubeni. There was a letter in the file from the Minister of Justice that the PP wanted us to access and to provide to her. It was apparently for an application either to be allowed or to be recognized as a legal practitioner by Mr. Ngubeni. I just wanted to clarify that was the only other event that we engaged on the issue of Mr. Ngubeni. I couldn't get the file and I was unable to trace the email. Now I can't remember the heading of the topic. Thank you, Chair.
Thank you, Mr. van der Merwe. Before Advocate Bauer, just to acknowledge, I I have read the chat, Mr. Theo Sianejo, that you are using another colleague's laptop. We note that. Thank you.
And Mr. Van Merwe, you took care of the mistake I made because I thought that I said August 2020 yesterday as opposed to August 2022. If I just took a minute to recap where we were at yesterday, we were at the invoice of page 3382, which dealt with a tax invoice which Sianejo Incorporated had rendered, to which was attached an invoice of 390,000, and that invoice of 390,000, I should have pointed out something to the committee yesterday. It's attached to your supplementary affidavit at page 4185.52. If you could just go there, go to the bottom of that page, on page 4185.52 of your supplementary affidavit. Go down to the bottom. Right, there we go. Right. So we see from there, it says invoice number SS KH.119 Vekuneni BS Pty Limited equal to 120,000. See that, Mr. Van Merwe?
That's correct, yes.
And then it says total billing rate 2,000 times billable hours 135. And if we tally the amount of hours on the invoice, you come to 135 times 2,000, you get 270,000. Do you know this entity called Vekuneni BS Pty Limited?
No, again, I checked with our supply chain and it's not on our database of consultants or service providers.
Okay, we understood when we saw this that the SS stood for CIEP and the KH stood for Kimala. So we addressed correspondence to them. And if we go to bundle I, page 195.1, it is the response we received from Professor CIEP. And if we go to the bottom paragraphs at, now the one, that's the second letter. The first letter is at bundle I 195. Let's see if it's that one. It could be. It's a response from 26th October. Let me just read it while Chepo gets it. It's a letter in which they deal with a number of issues, but what they confirm in paragraph 3, it's a letter dated 26 September 2022. To do that. And essentially they say the committee has access to the proposal that was presented to our office in 2018. We went through that proposal, correct, Mr. Van Merwe, yesterday?
Yes, that's correct.
For reasons that have nothing to do with the incompetence, that proposal was not concluded. That's the correct letter. I'm reading at number 3. And then it goes on and says, subsequently in mid-2019 and for a period of 3 months, strategic communication services were provided on an ad hoc part-time basis to Advocate Paul Ngubeni, who was assisting Sianejo attorneys on matters of legal services and opinions. No services were provided beyond the 3 months period. And if we turn the page, it says the invoices to support services rendered were duly submitted through Vekuneni Business Services registered in 2016. And Mr. Van Merwe, if it was not created for the services of the public protector, if you recall yesterday when we read through the email from Ms. Haller to Efren Kabinda, which was on page 3143, the very last sentence said in this regard, a registered entity is in place. Do you recall that, Mr. Van Merwe?
Yes, correct. At the last point, in this regard, the registered entities.
And then it says indeed, Mr. Shachwayo is the sole director. My relationship with Mr. Shachwayo goes far in 2019. And if we turn the page, there's a statement of fact. We go to page 195. The next page. Right, there's a statement of fact which they put out into the media domain on the 11th of September. And I'm not going to repeat what it said, but at paragraph 5, it says, at no time was any money paid to us by the Office of the Public Protector. Right. And then we go to bundle F. There was then further correspondence from us and a follow-up because we requested the invoices that had been provided under the name of Vekuneni Business Services, which is at bundle F, item 168, page 3679, which is a letter of the 24th of October, in which in the first paragraph, it was confirmed that we provided our services this time to Mr. Paul Nkubeni, who was contracted by the Office of the Public Protector as opposed to advocate. And then if you go down at the bottom under second, it says, second, in providing our services to a client, our invoices have detailed what we consider to be fair value. It is the responsibility of the client to determine whether what is billed is commensurate to services provided. Third, while we have been in conversation with the Office of the Public Protector as far back as 2018 regarding possible provision of strategic communication services, our proposal was not successful. We subsequently rendered similar services through Mr. Nkubeni's consultancy for a brief period of 3 months in 2019. And then as regards the specifics that fall within the engagement with Mr. Nkubeni consultancy, number one, they attach the invoices. They tell us there's notes and recordings. They don't have minutes. And then they say in 3, the invoices submitted to Mr. Nkubeni provide details of breakdown of rates, works, and hours. And in 4, they say we had no direct working relationship with Theo Sionego or Sionego Attorneys Inc. except for the email communication regarding meetings amongst others. We were engaged by Mr. Nkubeni and they attach a tax clearance and deal with procurement issues. In the very last sentence at the bottom, it is unclear to us how any subsequent engagement with the client outside the stated 3 months period of rendering the service is of relevance to the inquiry. If we turn the page, Mr. van der Merwe, are you aware of them having rendered any service at all to the Public Protector or the Office of the Public Protector?
Are we talking about Professor Siepe and Kim Haller?
That's correct. You have personal knowledge of any of it?
No, not as a direct engagement. Not to my knowledge.
Right. If we then turn to the invoice, and the invoice was provided to us, we see that there's no name as to who the invoice is rendered to on the invoice. But if you go down on the invoice, you see the reference is SSKH 119, which is the same reference as on the invoice on the Nkubeni consultancy invoice, which is attached to the Sionego invoice at all. And then we see the hours and the work that was done to the tune of 120,000 Rand for 65 hours. Mr. van der Merwe, you had an opportunity yesterday to look at the proposal put forward by Ms. Haller and Professor Siepe to the Public Protector. Does the rate and the hours correspond to what was contained in that proposal?
Yes, that was exactly what they proposed. And in the breakdown as well, when they requested to provide clarity. It's exactly as per this invoice.
And it's for the period, this one for 7 June to 4 July. If we turn the page and we see the second invoice, we see it's for a total of 99,000. And there's breakdown of hours for reading, research, articles, writing, publications. They put out 3 articles, 11 hours of interviews, on radio and TV, scheduling, including ETV, SABC, SAFM, 9 hours of social media, narrative building and activation, and then briefing notes and lobbying, 3.5 hours, 5.5 hours, meeting and correspondence, and they indicate that a summary and impact report will be provided at the next meeting with the office. Are you aware of any summary or impact report being provided to the management committee at the Office of the Public Protector?
No, as I said, this project was not reflected in any of our decision registers or any of our feedback reports, either from communications or from any of the other offices in the Public Protector. So no.
If we then turn off where we left off yesterday, which was on page 3208 of bundle F, item 161. Right. And you see, this is an email dated 19th June 2019 from Mr. Ngubeni to Mr. Sinego, the late Mr. Niembi, Ms. Haller, and Professor Siepi. Do you see that?
That's correct, yes.
And the subject heading said Judge Talmay's proposal to stay matters until Concord decides on cost. Do you know what that relates to, Mr. van der Merwe?
Yes, there was a ruling on the merits of the matter by Judge Talmay, but she didn't want to rule because the issue of cost, personal cost, were going to the Concord. It was a subject of litigation in the Concord, and there was a proposal that the judge would not rule on the issue of costs in the High Court matter until there was a ruling by the Concord on the issue of personal costs.
And then Mr. Ngubeni renders advice that says, I propose you reject the judge's proposal to defer the appeal until the Concord rules on costs. And he says about 6 lines down, there was no compelling reasons for a decision. It was a purely political, carefully calibrated move to assist the DA and CASAC. There is a way she can mitigate the prejudice to Advocate Mkubani. The judge can rescind the judgment and then wait until the Concord rules on the other issues, including costs. She took a gamble and now she pretends to care. I suggest that you reject her approach. Thanks. Was this proposal, as far as you're aware, ever put before the management committee?
No, I don't have any recollection that it was ever proposed to or considered by the management committee.
If we go to the next page, we see the public protector responds and says, thanks, advocate, agreed with the proposal. Right. If we proceed to the next page at 3180. This is an email dated the 13th of June, 2019, where Mr. Ngubeni writes an email that says, should we challenge the BUSA self-style petition? Now, BUSA stands for Business Unity South Africa.
South Africa, that's great.
Right. And as I read the email, they had put in a petition to the National Assembly for the removal of the public protector. Do you recall that, Mr. van der Merwe?
Yes, that's correct.
And according to this email,
to
the speaker, that's correct. According to the email, this email, it was a non-compliant petition. And if we go to 3182, we see Professor Siepi responding to the email to Mr. Ngubeni, Mr. Sienego, and the Chief of Staff, and agrees with Mr. Ngubeni. And if we go to 3184, we see the name is, I think, deleted because it's just the email address, but it's from Ms. Haller, and she says, agreed, Paul, can you draft an initial letter which the team can review prior to distribution?
That's correct.
Do you have a copy, Mr. Van der Merwe, that the from is not deleted?
Yes, yes.
Can you
It is
confirm
from
that
Ms. Haller.
Right. And she asks Paul, can you draft an initial letter which the team can review prior to this distribution?
That's correct.
Correct?
Yes.
And if we go to 3186, we see that Mr. Ngubeni distributes it. If you go further down, it's addressed to the Honorable Speaker, and it says representations in opposition to incompetent, misguided and misinformed calls from BUSA to institute removal proceedings in respect of the Public Protector, Ms. Busisiwe Mkabani. And number 1 reads, background to BLF ****. Mr. Van der Merwe, do you know what BLF stands for?
Yes, in our correspondence where we encountered them, it stands for Black First, Land First. It was an organization or an NGO.
And if we go to the top of this email, Mr. Ngubeni writes, dear colleagues, ideally the letter should be sent by an NGO or activist outfit. It is not a good idea to send it on behalf of the Public Protector. Please think it over and correct whatever errors, spelling, grammar, and substantive. It should read as follows. Do you know, Mr. Van der Merwe, whether this letter had ever been sent?
No, we tried to check. Well, it was not sent by our office, and I don't think we were able to get any record of it being sent to the Speaker's office. It was not in the public domain.
And at 3193, if we go down, we see Mr. Siepi saying, this is an excellent letter. Clearly, BUSA has displayed not only its legal incompetence, but also glaring ignorance of the fact. Importantly, given that the stone throwers have dressed themselves, including this petition is self-serving, we will be guided by colleagues on the way forward.
That's correct.
And if I take you back to the fee invoice by the consultancy, which is attached to 2482 of your opinion, and we go up to the line item at the 12th to 13th of June 2019. We see drafted correspondence urging challenge to the BUSA self-styled petition, drafted letter to the Speaker, 9 hours. And while I'm there, Mr. Van der Merwe, the next item says 13th June 2019, drafted legal opinion on Waterkloof and Zonder Commission. Do you know what that's related to?
Yes, we had a complaint about the Gupta landing, the plane at Waterkloof Air Force Base. And there was an issue following the state of capture report. There was a request for information or records from the Zonder Commission. And I can only imagine that they were asked for services in that regard. It was two matters then that was dealt with internally by the office.
Okay, so if I take you to page, back to the bundle at page 3220. And if we go to the bottom, not right to the bottom, but sort of in the middle. Oh, all right. It's an email from Mr. Nkubeni to the PP saying, attached, please find the rushed legal opinion. Time is of the essence. I could not be dilatory in the matter. Please let me know if anything is amiss or left unanswered. In my view, the public protector must cooperate with the Zondo Commission, but must explicitly inform the Commission that it is not answerable to the executive and that the public protector is not a department of state or administration, and neither can it be said to be part of the national, provincial, or local spheres of government. Mr. van der Merwe, was there ever any question that the Office of the Public Protector should or should not cooperate with the Zondo Commission?
No, the internal feeling was that the Zondo Commission was the result of the Public Protector's remedial action in the state of capture report. If anything, it was an extension of the Public Protector's investigation. So any suggestion or any hesitation that we should not cooperate would be actually undermining our own work and our own investigation in the state of capture matter.
And if you go up, we see the response from the Public Protector says legal opinion well received and agreed with. So if we turn the page to 3211, 3211, sorry. Yes, this is the legal opinion. And the first question is, our consultant seeks advice on a series of questions relating to the finalized Public Protector investigation into the Waterkloof landing. The first straightforward issue is whether the Public Protector is legally accountable to the State Capture Commission about the investigations, a final report and actions closing or dismissing an investigation. A related question is whether the State Capture Commission has any review powers over a final decision of the Public Protector and whether the said final decision is only reviewable by a court of law. And those seems to be the issues that came up and on the opinion that was rendered. And if you go to page 3219, the opinion is signed or submitted by Paul M. Nkubeni. Sorry, Mr. van der Merwe, just take a step back. Was the same questions considered internally by the office as well?
I wasn't part of the Waterkloof investigation or the state of capture report. I just know that the late Mr. Madiba and myself, because there was an issue of access to information, and we were instructed to provide the State of Capture Commission with certain records. I'm not sure if there was in pursuance to or whether there was a decision taken in that regard by the office, but we did cooperate.
And then if we turn to page 3222, if we go down to the bottom, we see that there's correspondence. Please find attached correspondence for the attention of the Public Protector, Advocate Pusisiwe Mkabani, who's, and it comes from Weber Wenzel. Correct?
That's correct, yes.
Right. And if we go scrolling up, we see that the email is then provided by, if you'd have to go to the next page, the earlier page, but we see that Efren Kabinda then forwards the email on to the Public Protector, the Chief of Staff, who is Rodney Mataboge.
And one of the chief investigators, senior manager investigations at head office.
And if we go further up, There's a request from the PP to Muntu Setauli. Please request Sienego to respond and rebut this. I will not withdraw or apologize.
That's correct, yes.
Further up. Mr. Setauli responds, you just missed it, you went past it. Right? Mr. Setauli responds and says noted PP. Right? And then we go further up and we see the heading of Advocate Nkubani's email says subject urgent demand publication of false and defamatory statements regarding Messieurs Ivan Pillay and Van Lachenberg, correct?
That's correct, yes.
And then the email deals with there is proof of threats to arrest for money laundering, threats to poison me, and actually my protector has been poisoned. We have proof from the doctors. My car tampered with, witnesses who fear for their lives confirmed 2 people who died mysteriously when they spoke about the rogue unit. Vieja arrested for rhino poaching after speaking out, open bracket, setup, close bracket. Mokoena charged for non-existent tender irregularity and frustrated until she resigned. Do you know what this related to?
No, only one of the incidents I'm aware of, and that is the issue of the, I suspect these were issues that the public protector raised as making her unsafe or related to this matter of the rogue unit. But I'm only aware of the one incident about the protector, the alleged poisoning of one of the protectors.
And what are you aware of?
We were recently requested to deal with the issue of the public protector's accommodation, and in the process, and I don't want to reveal information about it, but in the course of that, we looked at the issue of threats assessments being done, and there was an issue that was raised about one of the risks or threat that was identified was an incident where one of the protectors fell ill. According to the report that we received or that we had insight into from the protection services, he was interviewed, and it was actually, they didn't find any poisonous substance in his body. It related to issue of overindulgence in some food, Kentucky or something like that. It related to not related to an incident of actual poisoning or threat. That was the police's report on the matter. They did an interview with the protector, and that was his explanation.
Okay. If we then turn to the Annexure 24A2, going back to the invoice at 418552, and you look at the top entry, it says, receive urgent demand publication of false defamatory statements, Ripple and Van Lachenberg from Weber Wenzel, research Sikakane report, Kruin and Nugent reports, and research defamation law, read PP's address to sheriffs, 4 hours. Right?
That's correct.
Right. And you know that the Sikakane report, the Kruin and Nugent reports relates to the investigation into the alleged rogue unit, correct?
The SARS matter, yes.
Yes. Let's call it the SARS matter as we proceed. And then we turn to page 3226 on F161. We see on the 30th of June, Ms. Haller sends an email, please find attached for tabling at tomorrow's meeting an overview of strategic communication activities over the past 3 weeks and some recommendations on the next step. And she sends this off to Mr. Sienego, the public protector, and included in this email is Mr. Siepi, the late CEO, Mr. Nyembi, but she also includes Mr. Sagalwe, who's the spokesperson. Correct?
That's correct, yeah. It was the late COO, the Chief of Staff, Mr. CM.
Right.
Mr.
And
Nyembi.
included in this email is the CEO, Vusi Mashlangu, and Mr. Muntu Sitauli.
That's correct.
And if we go to page 3228, we see that those who were in the email received the feedback report that she provided. And it details the strategic communication focus over the past 3 weeks is there. And she explains in this report, if you go to paragraph at the bottom, our work, just go down to the bottom, the last paragraph. Our work has been orientated around high impact initiatives and interventions that influence and shape desired outcomes. We have sought and secured prime space and audience on radio and television and in newspapers. We have also pursued and delivered a high presence social media campaign. Our media interventions have been coupled with advisory notes to the office and briefing of key influencers behind the scenes. We believe we have managed to cause some disruption of the master narrative and succeeded in spearheading multiple calls by others for attacks on the public protector to cease. Did you see any of these advisory notes that was provided to the office?
No, I was just thinking that this report or none of these feedbacks came through the media reports. We do receive on reports from the communications unit at Manco and also at the PP's dashboard, and this was not reflected in any of those reports.
Right, and if we go to the next page, we see there's the 120,000 at the 1850 that was rendered into the invoice to Mr. Ngubeni, which is the 65 strategic hours. And if we continue in the report, page 3, they detail what the media specific activities are. 3 opinion pieces, radio interviews, 1 television interview, and go down, bottom, the very last item. 9 social media activations, over 250,000 impressions. Do you know what impressions are, Mr. van der Merwe?
No, I'll have to speculate. I don't know.
I'm not sure, but my children tell me it's every time you make a hit on one of the social media, you leave an impression, but let's leave that for a moment. At 3232, the next page. We're looking into the feasibility of public televised colloquium on the deliberate manufacture of discontent and partisan eyes wide shut approach of media to the truth. And a little bit further down, they're advocating decisive legal action against those who trade in propaganda without evidence and harm the reputation and standing of the public protector is recommended. And if we go to the very last line on the page, we see that it's submitted by Professor Sipho Sihepi and Kim Haller.
That's correct. Yes.
And if, right, I want to go back to page 3225. We go to the bottom. We see an email from somebody called Salvation Mohatle. Do you know who that is, Mr. van der Merwe?
Yes, he's in communications. It's one of our staff members.
And he sends off what is called a media monitoring report on the 26th of June 2019. Do you know what that is?
Yes, communications, scan, media, the public space in terms of media reports and statements and so on. And then when they pick up something that relates to the public protector or even matters that may serve as an initiative for own initiative investigations, matters of public interest, then they distribute it to the management and leadership.
Okay. And if we go to the top of the document, to the next email, just stop there for a moment. We see Chair, I'm in your hands. I think the public protector's just probably taken a bathroom break.
Continue.
If you see on the middle of the page, there's an email from the public protector that says, "Good afternoon. Please rebut the City Press article."
That's correct.
And would your media monitoring report that comes from your own communications department have included any articles that deals with the public protector?
Yes, that's correct.
Okay. And then if we go to the top of the email, it says, "Dear Advocate Mkubeni," and it comes from Kim Haller. And we see again, Kim Haller has included the public protector, Mr. Segalwe, Mr. Niembi, and Mr. Sitauli, as well as Mr. Sienego, in this
That's
email.
correct.
And it says, "Dear Advocate Mkubani, I have written a piece that will be published this week, which will help in part to respond to the specific article. Further to this article, we are looking at a specific CX one for next week. The piece written by the professor last week also addressed some of the misrepresentations found in the City Press piece and so many others across the mainstream media. The professor's article has helped to shift the agenda and has been very well read and widely distributed. We are meeting with the team on Monday and will share an impact as well as cement upcoming communication initiatives." And we see it signed by kind regards, Kim. Correct?
Yes, that's correct.
And we then go to page 3233. Right. We see Mr. Nkubeni on the 1st of July, 2019. What does the heading read, Mr. Van Merwe?
Advisory opinion on urgent need to litigate matter of section 194 removal.
Right. And then he says, "Attached, please find a discussion document I prepared in anticipation of our meeting. Unfortunately, I could not make it due to transportation issues. I firmly hold the view that the only solution to the incessant political attacks on the public protector by those MPs, politicians, and their allies being investigated or found guilty of corrupt and unethical behavior is a declaratory action in court and an interdict which would effectively bring to an end the cycle of retaliatory actions against the public protector and put an end to the abuse of the process of Parliament. The PP, or at least her effectiveness, will not survive the current lynch mob frenzy being seemingly endorsed by the Speaker. Please consider. Thanks." Are you aware of a discussion on the need to litigate taking place at the Office of the Public Protector?
Not on the levels that I was engaging in. No, such a strategy was not discussed internally, as far as I'm aware of.
If we go up on the email, it says from the Public Protector, thanks, advocate noted.
That's correct.
And if you turn the page, you see the opinion is provided on page 3235.
Yes.
And it runs for several pages. Now, Mr. Van der Merwe, I just want to interrupt this flow to draw your attention to something which had happened the previous year, which would be in a different bundle. And if we could just turn, actually, let me do this. I'm not going to take Mr. Van der Merwe out of the flow, but I want the committee to just note this, because at some point during Mr. Van der Merwe's evidence, I'm going to revert to what the bills were in 2018, and it touches on this opinion as well. Right? So instead of me disrupting the flow, I'm going to continue. Shepherd, just tell me what that page was again. I've now managed to. Okay.
3235.
Right, and the opinion carries on until 3249. We note that the note is not signed, and the conclusion says no amount of PR work undertaken on the matter will ever overcome to determine insidious efforts of the well-resourced culprits running scared. Only a court action for declaratory relief directed at Parliament would put an end to the abuse of the process.
That's correct.
Now, if we then go back to the annexure to your affidavit at 24A1, and we see the next entry was the correspondence on Judge Tolmay's proposal, which was 2 hours, which I took you through. And then from the 30th of June to the 1st of July, researched and drafted advisory opinion on urgent need to litigate matters was spent 13 hours. All right. And then so that we don't come back here for the next one, you'll see on the 2nd of July, read correspondence from Accountability Now regarding holding the public protector to account, research allegations on the Absa lifeboat matter, in which Parliament is ordered to change the mandate of the Reserve Bank, a matter about which AN had allegedly not complained, wrote advisory on need to write to speak about referral of PP removal matter to a committee. And that's 4 hours. So if we go to bundle F at 3250, and we go to the email which Advocate Paul Hoffman sends on the 2nd of July. Do you know who Advocate Paul Hoffman is? From which organization?
Yes, he's from the director, I think, of Accountability Now.
Right. And he was initially the complainant in the Absa CX matter, correct?
That's correct, yes.
And he addresses correspondence to the Parliament, and he includes the public protector in this correspondence. Correct?
That's correct, yes.
And if we go to the top of the email, we see that the public protector sends this to Mr. Ngubeni, Mr. Sienego, Mr. Satauli, and Mr. Niembi.
Yes.
Correct?
That's correct.
And we see on page 3252 Mr. Ngubeni responds and says, herewith is the letter to the speaker. It is deliberately detailed and long because we need to put an end to the abuse of the parliamentary process. The speaker is the gatekeeper under the rules of parliament and the constitution. We are asking for a rescission of the decision to refer the matter to a committee, as this was done in violation of the public protector's due process rights. We leave open room for constructive engagement with the speaker and to assist in putting an end to the abuse of the section 194 process. Thank you. So we see that the author of the letter is Mr. Ngubeni, correct?
That's correct, yes.
And if you turn the page, we see at the bottom an email from Mr. Hoffman. And it's a letter to the Legal Practice Council.
Yes.
And the public protector is included in this email. And it is headed Advocate Pusisiwe Mkhabane, Mero Motu disciplinary proceedings required.
Yes.
And he is asking the Legal Practice Council to take note of the findings of the Constitutional Court in the matter between the public protector and the South African Reserve Bank. Correct?
Yes, that's correct.
And if you go up to the top, we will see Mr. Ngubeni responds to the public protector, Mr. Satauli, Mr. Sahalwe. Who's Alfred Mshlongo again? Just remind me.
He was the senior manager legal services at the time.
And he says this is actually rubbish. We must ask for reconsideration. Failure to accord the public protector decisional independence exactly equal to that afforded the judiciary effectively nullifies the provisions of Section 181 of the Constitution. The PP's ability to function without fear is destroyed, as she must view every case as a potential financially ruinous risk that may bankrupt her. The PP must request reconsideration in the Concord to revisit the practical effect of the judgment on her work. The 4 acting judges will be gone, and the regular judges, including Madlanga, Zondo, etc., will deal with the matter. As for Paul Hoffman, he's just giving us a chance to revive a case that was swept under the rug by the GCB after they decided he was to be presented in court for a striking off application. He benefited from that favor and now he's making noise. We shall vigorously deal with his nonsense. Do you know what court case is being referred to, Mr. van der Merwe? Concord decision in respect of the private cost order or the personal cost order against
the
public protector.
Yes, it was the decision of the confirmation of the Constitutional Court of the personal cost order against the public protector, where I think the Chief Justice was in the minority.
Right. And then if we go to page 3271, we see Mr. Ngubeni then addresses a response. And in this response, I note that Mr. Satauli, unlike some of the others, is now not included. But he says, I suggest that we develop standard responses for lunatics like Hoffman and not waste much time trying to be reasonable with them. We know the evil agenda. And there is then a response crafted on the Hoffman inquiry. Correct?
That's correct, yes.
And then, as I already showed you, that was the 4 hours that was attributed in the invoice. And then we go to page 3273. We must go down. The very first email is actually a communication which starts on 3274. My apologies. We see an email from a gentleman called Dumsani Shlapo. Do you know who that is?
I've only noted from this email that he was involved in the Masiphumelele community. But I personally don't have any knowledge of him.
Okay. And he then embarks on a communication. If you go up with Mr. Hoffman, who then inquires from him, how much help have you really had from the Public Protector's Office? Go up. He responds to that email. Go further up. The Public Protector then forwards this email on to people within the office, and go up. We see Mr. Satoli responds and says, "This is really humbling. It deserves to be spread as wide as possible." Correct?
That's correct, yes.
And then if we go further, at page 3276, we see Mr. Mshlungu indicates, good evening, Chief of Staff, and Mr. Satoli is included, Mr. Nyembe is included. He says, "I've just spoken to Mr. Satoli and undertook to respond to Hoffman. I'm forwarding the draft piece below prepared by Advocate Nkubeni to assist him in doing so." He said he will copy us.
That's correct.
Are you aware of a response that had gone out from the office?
Not that I'm aware of, no.
Then if we go to 3255, we see there's a draft answers to some of Hosanna Sunday Times questions. You see that?
That's correct, yes.
And is it so that you would from time to time get questions posed to the office from the media that you would respond to?
Yes, so all the time, the communication, specifically when Mr. Sehalwe was here, would distribute questions to people that he think might have relevant information, and then we would be required or requested to provide inputs to the questions.
And
these days it's done.
Sorry, Mr. Van der Merwe, I interrupted you.
Sorry, no, these days it's easier. It's done not by email, but via WhatsApp communications interest group within the office.
And so here we see on 2 August, Mr. Nkubeni responds by providing the answers. And if you go up to the top, you see the Public Protector responds and says, "Brilliant response, Advocate." Correct?
That's correct.
Okay. And there's just one thing I want to draw to your attention in the response, which is the answer, the last section. No, it's fine. Let's go to 3262. And we go to the bottom. And it's Mr. Sinego saying, good morning, Mr. Mhlongo. I seem to remember a conversation between you and I where you mentioned that we are appealing Judge Patrol's judgment. I also believe you mentioned that we need to meet with the EFF's attorneys to align our strategies. Kindly advise if we can go ahead and arrange a meeting with the EFF's attorneys. Mr. van der Merwe, it says case number 48521/19.
Yes,
That is the case dealing with the SARS unit, correct?
that's correct. Yes,
And the complaint in that matter had been made by Mr. Floyd Shivambo, correct?
no, that's correct. Yes.
Would it ordinarily be the case for the Public Protector's Office to align its strategies with the attorneys of a political party?
Not in my short experience in legal services and in terms of our litigation approach. And I would also imagine that it might have an impact on our independence and impartiality to be aligned to specific parties' legal strategies.
And then if you move up on the same chain of emails, we see it goes to the Chief of Staff as well as to the Public Protector. And Mr. Mhlongo responds and says, good morning, Mr. Sinego. I confirm my instructions that the Public Protector is appealing the judgment. We will advise you as discussed telephonically this morning of the counsel we will be utilizing for the appeal. In the interim, kindly proceed with setting up the meeting. If necessary, they can have their counsel present. Depending on who we have on brief, we can do the same. I have a brief discussion with Mr. Satoli during our meeting this morning. We are both leaning towards Paul for SC, but we will confirm with COS and revert.
That's correct.
Right. We then turn to page 3264.
What is that?
I don't know what that is
I
now.
suspect
It's
it's the NCOP
coming
setting.
from. Come again?
OP bells,
Is it NCOP bells?
I suspect so.
Because I can see there in that machine the red thing. ICT, is that part of your system doing that? Not yours. Okay, so I hope so. Honorable Dlakude says NCOP bells. I hope they stop because they are really disturbing us. We don't need bells here. Thank you. Don't know why they must be coming in here. We're just few minutes away from break. Please continue, Advocate Bauer. Sorry for that to everybody.
On the page 3264. It then is an email from Mr. Sinego. I hope you're well. Further to your mail of Friday, 2nd August, kindly advise on the counsel you would like to brief for the appeal. Would you like new counsel to work on his own or to work with Advocate Masuku SC? Mr. van der Merwe, in the court below, in the High Court matter before the appeal, Advocate Masuku was the counsel in the matter, correct?
That's correct, yes.
Right. And then if we go to 3263. We go to the bottom. It says, good morning, Mr. Sinego, from Mr. Mhlongo. I've just spoken to the COS and he has confirmed with the PP that we are retaining Advocate Masuku SC in the matter. he accordingly has to deal with 3 aspects of the matter. Let's go down to see what those 3 aspects are. That is the application for leave to appear in respect of the urgent interdict from Judge Potterell, the review application in the main proceedings, the interlocutory application from the Minister of State Security to exclude the intelligence report from forming part of the court processes. We will revert to you regarding a junior for him shortly, given Advocate Mankle's recusal during an acting stint on the bench. Kindly do not hesitate to contact me. Mr. Van der Merwe, that intelligence report is the IGI report that had already been discussed in this committee, correct?
That's correct, yes.
Right. And then let's move up on the page 3263 to the middle. The public protector then sends an email off a few minutes later that confirms I agreed, provided we use Ngubeni to support Masuku. Right. And then further up on the email, it says, kindly contact Advocate Hangwi Matlapi as a replacement for Advocate Monkey. So now we have a junior and a senior counsel and Mr. Ngubeni. If you go further up on the email, we see the senior legal services manager, and he includes Mr. Satoli, Mr. Sinejo, and the PP in the email with the Chief of Staff. Good afternoon, Mr. Sinejo. I confirm the emails below from the PP and COS. We will accordingly have Advocate Tabani Masuku SE, assisted by Advocate Hangwi Matlapi, with Advocate Paul Ngubeni SE providing support in the background. I trust you will find this in order. To the best of your knowledge, is Mr. Paul Ngubeni an SE?
No. As I said yesterday, we couldn't even confirm that he was indeed admitted. And I think he addresses that in the communications. But he is definitely not an SC.
Right. And then if we go to page 3281, we see Advocate Masuku sends off the draft answering affidavit in Minister of State Security and PP, and he sends it off to Mr. Sianejo, Advocate Matlapi, and Mr. Ngubeni. Could you kindly consider this answering affidavit and give me your comments? I've highlighted the areas that I wish some instructions and comments, and I'm toying with the possibility of a counter application directing the minister to give a declassified IGI report. I accept that disclosure of names may create problems, question mark, question mark. And then attached to that is a draft affidavit, which we won't deal with specifically. We then take it to page 3294. The bottom, Mr. Sinejo takes the draft answering affidavit and he says, kindly forward any comments, suggestions, questions that you may have so we can finalize it. And he sends it to Mr. Satoli and Mr. Mshlungu, and the Chief of Staff go up. And we see that the PP is provided with a copy of it. Please find the email below from our external attorneys enclosing the draft answering affidavit in respect of the application, excluding the OGI intelligence report from the Rogue Unit review application. May I kindly request you to review the draft answering affidavit concurrently with us so that we can provide consolidated feedback to council. Go up. And the PP then responds with 4 comments in respect of the draft that's been provided. To do that. And then if we go to, correct?
Yes.
Right. And she, in fact, let's not leave it there. She comments on 2 of the paragraphs and she answers the question that he asks as to whether a counter declaratory should be required. And in paragraph 20, it says, we only want the declassified report, not interested to the agents and sources. I agree, we avail copy of to the judges in chambers. You see that, Advocate van der Merwe?
That's correct, yes.
Okay. We then go to 3298. Mr. Nkubeni then provides argument on appeal, Gordhan v. Public Protector, and it says, please find attached argument on appeal in the Gordhan v. Public Protector matter. I've done no spell check. And if you go up, you see that this is forwarded to the senior legal manager and Mr. Satolian, the chief of staff. Correct?
That's correct, yes.
Right. And if you go to page 3295, he also provides his draft of his appeal argument to the public protector inter alia, and he says, here it is my draft of the appeal argument in the above matter, shared with the attorney and relevant advocates. In the normal, well-functioning judicial system, I would predict a clear-cut victory, but now in the face of political mobilization of the judiciary, I'm just not sure. And he then lists a number of issues, and this arises from the judgment of Judge Potterell, correct?
That's correct, yes.
And that went on appeal and the public protector's office was not successful.
That's correct, yes.
If you go to page 3296. We see Ms. Haller comments on very powerful, painful observations on a compromised judiciary. And then if you go to page 3299, you will see the actual heads of arguments provided, and it runs for approximately 54 pages. Correct?
Yes.
Oh, 3253. Now, if we just pause there for a moment to go to the invoice, which is at 24A1 or 2, right? We see, if you go down to the 25th to 31st of July, we see that read Gordhan's urgent interdict and review documents, research jurisdictional issues and interdict legal standards, analyze Potterell's judgment, 22 hours, go back up. We've dealt with that, right? You will also see, just go a bit further up. Sorry, Shepherd, just go to the previous page. So I want to see if I've missed anything. Up, top. Yep. Okay, we're still coming to that. That's fine. If you see 6th to 10th June received in Nana, we'll come to that in a moment, right? So if you go to page 3356, right at the bottom, dated 31st of July. See an email from Mr. Nkubeni that says, subject Judge Potterell's unethical and incompetent judgment. And he calls Judge Potter's unethical and incompetent judgment in Gordon v. Public Protector. And it seems to be an article that is written, correct?
That's correct, yes.
And in this article, he starts off by saying Judge Potter's ruling in Gordon v. Public Protector and others is emblematic of an overwhelming miasma of fake law untethered to the record. Now, Mr. Van der Merwe, do you know what that means?
I think it's a collection of fake law. I know I checked the word, but I can't recall the meaning. I didn't make a note.
A collection of what? Can you just repeat that?
A collection of fake law.
Okay.
We had the opportunity of looking at what miasma means. Do you recall what that means, Mr. Van der Merwe? You had a look in the dictionary when we were consulting on this.
I know we checked, unfortunately, because there were a number of words, I got mixed up with the explanations.
It was an uneasy or unhealthy spell, if you recall, Mr. Van der Merwe. Do you recall that?
Yes, that was, I recall. Yes, that's correct.
Right. And then in the next paragraph, it says, in a haste to get on the pro-Paveen bandwagon, Potterl overreached. And in the last sentence, it says of that paragraph, a judge who uses abusive and contumacious language against the head of a Chapter 9 institution and characterizes her rulings as nonsensical, fails to follow the law, treats litigants inappropriately, and publicly displays contempt for the judicial system. Sadly, a careful perscrutation of Potterl's unenviable judicial record exposes her inverted, bigoted behavior and incompetence. On the next page, just go down to the next paragraph.
Sorry, Chair, for the benefit of the members, we checked that word perscrutation means thorough examination.
Okay.
I didn't get that. You are saying,
Perscrutation.
Mr. Van der Merwe?
Sorry, Chair.
Yes.
Perscrutation. It says a careful perscrutation of Potterl's judicial record. It's a thorough examination of her judicial record. Chair.
And then in the next paragraph I'm referring to is a litany of gross errors Potterl routinely makes in her judicial decisions. Also highlights that she does not observe the principles that in reversing the opinion of a lower court or quasi-judicial tribunal, such as the public protector, she must not insult the hallowed rules that the function of a court is to see. Now, what do you make of this, Mr. Van der Merwe?
The whole article, it's an attack on the Judge Potterl and criticizing her for a ruling in the Gordon versus Public Protectors matter. Yeah, it's very personal, and it attacks the judge on all levels, professionally and personally.
And if we
Thank you. You're going to take a pause there.
Can you give me 2 minutes to just
Okay.
finish this page?
All right.
Can we just go to page 3356? Go up. Go down, sorry, down. Further down. In response to the article, the public protector responds, the article is perfect, advocate, though the language used is very complex for her to understand. Should have used simple language so she can get the message. That is the public protector's email, correct?
That's correct, yes.
And then Mr. Ngubeni responds and he says, what angers me is that Potterell wrongly convicted and sentenced Black Eyes in a judgment the SCA described as one where there has been a gross departure from the established rules of procedure, that the appellants have not been properly tried. This is per se a failure of justice. Are you familiar at all with any of Judge Potterell's judgments? Have you had anything to do with it?
Yes, at one point I was requested, I was given the names of a number of judges, and I had to check for the public protector if any of their judgments were set aside or overturned on appeal, either by the SCA or the Concord. And I don't have the document now, but I know that and Judge Tolmay, Potterell, and a number of other judges were on that list of names that we had to check whether their judgments have been overturned.
Okay, just go up to the last email on that page. And it's an email from the public protector that says, good afternoon. Please incorporate the below arguments by Advocate Nkubeni. Alfred, collect my handwritten notes on the affidavit to be incorporated. Further, page 50 of the report and 134 of the court papers, I referred to the IGI recommendations and not the whole report to protect the agents on the operations. And I said legal must make sure Rule 53 included only the pages relating to the recommendations. Further, I did check whether we gave the correct recording of those who confessed. Please work on incorporating some of these issues. Right? That relates
That's
clearly
correct.
to the SARS matter, correct?
That's correct, yes.
Thank you. We will pause there and take a break and be back at 11:45.
Recording
Thank you.
stopped.
Colleagues, we resume. Mr. Cornelius van der Merwe, are you there?
Yes, thank you, Chair. I'm back.
Or are you still trying to get something? Are you ready?
Yes, I'm ready. Thank you, Chair.
Just help us so that we don't lose you. Just keep up your voice and make sure you speak closer to the mic so that we need to hear every response you put forward on these issues. Stay in that way. We don't want your voice to go down and then I have to ask you to repeat. Thank you.
Thank you, Chair.
Advocate Bauer.
Can we then go to page 366? We're still on bundle 161. 366. Going to be working forward. We're starting with the earliest email at the bottom of the page on 336. It's an email from Mr. Sinego to Advocate Masuku. Good afternoon, Tabani. I hope you're well. I have included Advocate Matlapi, Hungry, who will be assisting you. As you're aware, we have the following matters, and he then lists the matters that's relating to that. And these are all matters involving or tangentially involving the SARS unit matter, correct, Mr. van der Merwe?
That's correct, yes.
Right. Then, if we go to the top, Advocate Masuku confirms the amount of days for the appeal. And if we go to the previous page 3365, we're told that the application for leave to appeal is due on the 20th, and they will map the way forward. If we go to 3364 at the bottom, we see Advocate Masuku provides an affidavit for our application for leave to appeal together with Hungwe. Please make sure that it reads well and raises the issues that we need to raise. Find somewhere to attach the silly judgment of Pache Hungwe. Please draft a notice of motion. I will forward you a draft form regards to Pani. Then go up. Just for the members, Mr. van der Merwe, the previous set of emails dealt with the affidavit in the Minister of Safety and Security matter, correct? The interlocutory there.
Yes.
And this deals with the affidavit in the application for leave to appeal the judgment of Procedural J, correct?
That's correct, yes.
Right. And then if we go to go up, Mr. Mshlongo says, good afternoon, PP. Please find the attached draft appeal papers in respect of the rogue unit urgent interdict. As agreed this morning with our various counsel, we are going to the Constitutional Court to petition it to hear the appeal. May I kindly request you to review concurrently with us so that we can finalize the file by tomorrow. Right. And the judgment of Procedural J, it's been a while since we dealt with this with the committee, but that was the appeal separately from the main case, correct?
Yes, that's correct.
Right. Then go up. We see Mr. Satoli provides his comments on the draft. Go further up. He brings the question of direct access to the attention, and then go further up. We see Mr. Sinego go to the start of it. Mr. Mshlongo then provides an email. Provides an email to Mr. Sinego, the Chief of Staff, the Public Protector, including Mr. Satoli, and says, good morning, Mr. Sinego. Further to Muntu's comments, the PP's notes and Advocate Nkopeni's contributions, please find the attached revised draft with my minor changes and comments for yours and council's consideration. So everybody's had an opportunity to comment, and then they say there are some issues which I think did not come through in the affidavit, which I also highlighted to you during our consultation yesterday with our various counsel as follows. And the first one is the fact that you cannot interdict a constitutional function or an exercise of a constitutional power. We'll park that for a moment when there's some argument. There must be extraordinary factors for doing so, which Jamandas has not demonstrated. Do you know who's Jamandas or Jamnadas?
Jamnadas. That is referenced as the second line of Mr. Minister Pravin Gordhan.
Right. And then it deals with the potteral judgment. And after the numbers, it said, kindly also solicit input from our other counsel as the application was sent to them, particularly Advocate Sikakani SC. So now there are other counsel also. Do you know if Advocate Sikakani SC was on brief in this matter?
No, I'm not sure.
And if we look at paragraph 3 of this email, Potterell committed an absurdity in the matter by premising a judgment on the strength of correspondence relating to another report, Ivan Pillay, in this matter. It would have been absurd for the PP and Cyril to exchange correspondence on the implementation of remedial action, which was not yet in existence at the time. Mr. Van der Merwe, this related to the PP's office saying to the president, I've issued a remedial action you must implement. In the absence of an interim interdict, the remedial action must be implemented, correct?
Yes, that was the approach, and that is indeed the approach of the public protector. Unless it's interdicted, it's binding and must be complied with.
Correct. And so unless you have a court order, you must comply with your public protector's report. Is that as I understand it?
Yes, that's correct. That's the legal position.
Right. And the public protector was correctly applying that standard even against the president.
That's correct.
Right. And then if we go to page 3367, we go down, we see the senior counsel saying he's got nothing further to add. He's leaving it to you, he's in court, and they must please clean up the notice of motion. And then we go to page 3386. We go to the bottom of that page. And it's Mr. Ngubeni, at August 27th, I've attached the affidavit with a few corrections I made. All in all, it is a well articulated, but I will suggest that the legal theory of the public protector's defense be made more explicit. And he then suggests that the court be reminded of the following. That the Minister Lordlaw is stalling rather than assisting the public protector. Just Mr. Van der Merwe, at the time of that, Minister Lordlaw was the Minister of State Security, correct?
State Security, yes. SSA.
Okay. All right. And at the end, the last sentence says that would preclude unwarranted shielding of information and hiding behind the veil of secrecy to prevent the public protector from doing her job.
Yes.
And he then goes on and says it is also at paragraph 2, it is also very important to be alive to the reality that members of the executive and others who have been investigated by the public, I think I omitted protector, are likely to adopt an obstructionist posture, and the classification of documents can be one such tactic used to deny access to evidence. And he then cites authority for this. And at the end, at 3388, he advocates a position that the affidavit must make a compelling case even for the future that security legislation and the whims of the executive must give way to the public protector. You see that?
Yes, that's correct.
And if we if we go back to 3386, we see the instruction to Mr. Sinego is we acknowledge receipt of the attached draft, which he forwarded. If you just go a little bit further down, you'll see that it's Mr. Sinego that forwards the draft onwards. Go up to Mr. Satoli. No, stop. Go back to the top. And we acknowledge receipt of the attached draft and the email input below from Advocate Nkubeni. We request that you kindly forward the input to Advocate Masuku and Advocate Maglapi to incorporate into the answer. I'm a bit concerned about timeframes. Right? And we see that the public protector is included in that email.
Yes.
Right. If we then go to 3390. We then go further down to the email from Mr. Nkubeni with an article written, can judgment in the GBA dismissal case provide grounds for impeaching President Ramaphosa? And we see, if you go up to the top, that he then forwards the article onto the Office of the Public Protector. I raise this because I'm going to come to invoices in a while that's rendered, and I want to make note, want the committee to take note of this. And the article looks at the actions of the president in having established the committee, the inquiry under the Public National Prosecuting Act for the removal of Advocate Jiva.
Yes,
Under 166 of the Constitution, correct?
that's correct. Yes.
And I maybe just get the sense of the article by taking you to the last line of it. On 3393. The president has dared the indomitable Jiba and must now pay the judges surreptitiously for a favorable outcome. We then go to page 3402. We see at the bottom, Mr. Nkubeni renders an advisory opinion on the accountability now litigation that has been instituted. He says, I have not been favored with a complete set of papers in the accountability now case. There was litigation which accountability now instituted against the public protectors of public protector, correct?
Yes, that's correct.
Right. And he says, in summary, we can and we must defeat the accountability now case. And he says on what that must be based in his email, correct?
Yes.
And if we go to the top of the email, On the top of the page, go higher. We see Mr. Senego forwards this to Mr. Mshlongo, Mr. Satauli, and the Chief of Staff. So all three of them would have been alive to the opinion rendered by Mr. Ngubeni, correct?
Yes, that's correct.
And he asks them, as discussed in our last meeting, we need to resolve this matter as soon as possible,
Yes,
right? And you find that on page 3403 is the advisory opinion on the application. And if you go to 3423, you will see that it's not signed, correct?
that's correct. Yes.
And if you go to 3424, it's an email of 9th October 2019 to Mr. Mshlongo, Mr. Satauli, and Mr. Niembi, correct?
Yes,
And it's a meeting regarding Nkobeni and Prof. CP.
that's the topic or the subject. Yes.
And he asks if a meeting can take place after the meeting with the DJP
Yes.
on that Friday, correct?
Yes.
And then if you go to 3426, go down. This is an address by the public protector during a social justice conference at the University of Zululand. It is so from time to time the public protector would make addresses or speeches in the public domain or be invited to talks, correct?
Yes. The PP and the DPP makes public engagements.
And who would usually do her speeches for her? Or would that be the communications department?
Myself and Opa used to do it. Mr. Segalwe, yes, communications and with when they require legal research or legal input or statistical inputs, they would ask me for inputs.
And if you go up on the email, you see that she forwards this to people in the office, and she says, attitude of these white NGOs towards social justice issue, CASAC, full accountability now, etc.
Yes.
And then at page 3400, this kind of email with a notification, is this the manner in which the office schedules meetings, Mr. Van der Merwe?
Yes, the private office would usually draft a weekly schedule of the engagements of the public protector, and then they would distribute it to people who would have to know. These are all members of the private office. Betty Tozama, Merwe, Letago, Mr. Nyembe, and the PP.
And that's presumably so that the people in the private office would know what the PP's business is for the week or something like
Yes,
that.
that's correct.
And you see, what do you see scheduled there on the 19th of December?
It's a meeting with Kim Heller and team from 9 o'clock till 11 o'clock. And then they say who is invited was the Chief of Staff, the CEO, Mr. Segalwe, and Legal Services.
Legal. And the CO at that stage would have been Mr. Vusi Mashlangu, correct?
That's correct, yes.
Right. And legal, Mr. Alfred Mshlongo and Mr. Muntu Satauli would still have been there.
Yes, that's correct.
Right. And you'll recall that earlier this morning, we looked at correspondence that had been received from Ms. Halle and Professor Siepi, where they indicated that they only were involved during the period of July and September 2019. Do you recall that, Mr. Van der Merwe?
Yes, it was in a letter and in her or Professor Siepi's letter, yes.
And this is dated the 19th of December 2019.
Yes, outside that period that she said.
Right. Then if you go to 3433. We see Mr. Ngubeni forwards a PDF version of the document that he sent yesterday. You see that?
Yes,
And if you go up, it is then forwarded to Mr. Satauli, correct?
yes,
Right. And if you turn the page to that, you see it appears to be the first pages of a draft. Go down. Are you aware of an application of this nature which the PP had brought, which includes the South African Human Rights Commission, the Gender Equality Audit General, Electoral Commission, and the Commission for the Promotion and Protection of Rights of Cultural and Religious Communities?
no, these were all members of what we call the FISD, Forum for Institutions Supporting Democracy. And it would have certainly been on the agenda for a topic for discussion there. And it was never, it never came to light that there was an anticipated or proposed or even intended application of this nature.
Was it discussed at Manco level?
No,
If you go to page 3436, this heading says PPSAV National Assembly of the Parliament, right? And if you go down, you'll see on the 24th of January 2020, please find attached the draft founding affidavit for your consideration. And it says revised PP founding affidavit edited in Ngubeni version.
yes,
And if you go up, you see the public protector is acknowledging receipt thereof.
that's correct, yes.
Right. And in this, CC'd in this is both Advocate Shabalala and Advocate Mahlapi, correct?
Yes, that's correct.
And they are the junior counsel in the litigation in the matter against the speaker. Is that correct?
That's correct, yes.
You also see Mr. Satauli as part of this.
Yes,
If you go to 3480. 3480. You go down to the email from Mr. Niembi. We're back in the timeline in May 2019. Right? And it's an email from the Chief of Staff to the Public Protector and to Mr. Satauli. And it says, good day, PP and Muntu. I've just spoken with Advocate Masuku SC, just checking his availability for us. We agreed to rather discuss face-to-face. He's in town next week on the 3rd of June. We will see each other then. Accordingly, we can suspend the completion of the team of on PG. PG presumably stands for Pravin
Pravin
Gordhan.
Yes.
Pillay Magashulu matter. We have Advocate Mpofu SC for now while we await receipt of Pillay and Magashulu's review applications.
Yes.
Right? And the public protector responds up and she says noted.
Yes.
Right? Then we go to 3481. It's an email from the Chief of Staff that says, in order to satisfy council's preferences, we propose to terminate VZLR attorneys and replace them with Senego attorneys. Given the speciality and significance of the matter, we think the proposal is sound and over financial year, the briefing pattern will average. Unless PP has alternative opinion, Muntu can prepare the necessary memorandum according to the above, and it's signed by the Chief of Staff.
Yes.
What do you understand from this email, Mr. Van der Merwe?
Yes, VZLR was the attorneys of record, and they were replaced by Messrs. Senego Incorporated. And I think in what we are referring to as council's preferences, that was in order to include the PP, the team that the PP wanted on the matter. Including Mr.
Ordinarily so that... Sorry, Mr. Van der Merwe, I interrupted you. Sorry.
No,
Complete
no,
that?
including Mr. Ngubeni. Sorry, Chair.
No, go ahead, Mr. Van der Merwe.
Yeah, because the practice was that the Mr. Ngubeni's invoices would have been channeled through Senego attorneys.
And if you go up on that email, you see Advocate Mkubani says agreed. You see
Yes,
that?
that's correct.
Right. Now let's just go to page
Yes.
3.
Please keep improving, Mr. Van der Merwe, so that some members who can hear you properly. So they have to struggle to hear you. Just make sure that you continue to raise your voice and connect properly with the mic that you have there. Please, Advocate Bauer.
Sorry. If we go to page 3439. Go down to the bottom. We see that there's correspondence in the Pravin Gordhan matter, the public protector to Judge Rolinga from the attorneys of Ian Levitt attorneys, correct?
Yes, that's correct.
Now let's go up to the next email. And Mr. Van der Merwe, those are the EFF's attorneys in this matter. Do you recall that?
Yes, that's
if-
correct.
If we then go to the second email, it says, the above matter and our telephonic discussion earlier this afternoon refers. Attached here to please find correspondence we sent a few minutes ago to the judge, which we believe is currently seized with the matter. Rolinga J, the contents of which are self-explanatory. And if you go down, it says, as discussed, we represent the EFF. We would like to join in this matter. However, we have not managed to have sight of the papers. Please, could you furnish us with a copy of the papers? Once you're in the receipt of the same, you inform me on the phone. You have still not been served with the papers. Correct?
Yes, yes, that's correct.
And then if you go up, Ms. Mohammed from VZLR attorneys responds and says, Dear Muntu, see below and attached as received from Ian Levitt attorneys for your urgent attention.
Yes,
Go to the previous page. She then inquires, is there any feedback on this matter? And then she then records, as telephonically discussed on 3 June 2019, I confirm that the new legal team was assigned to the review application launched by Mr. Gordhan in this matter. Once our final bill has been paid, should I proceed to close my file?
Yes, that's correct.
Right? So she confirms that VZLR attorneys is being replaced.
Yes, that the
Correct.
mandate was terminated.
Right. And if you go up, you will see that Mr. Satoli then tells her to close the file.
Yes,
Correct?
yes,
Then if you go to 3498. On the 1st of July of 2019, the heading says Strategy and Tactics Review PG/Pillay matter.
yes. Pravin Gordhan / Pillay.
Pravin Gordhan. Good day, PP and Mr. Satoli. Mr. Satoli, please bring this email to the attention of Mr. Mshlongo. I still can't pick him up from the email addresses. I've just received a call from Advocate Dali Mpofu SC. This is in respect of his concerns about our conduct of the brief he holds. He raises 2 issues, viz. Legal team and strategy. We have since agreed that I attempt to set up a meeting on Wednesday at the PPSA office. The purpose is to deal with the two aspects. We have tried to get Thursday after knowing whether or not they're supplementary, but there are clashes of time there. Ephraim, kindly check with PP whether the proposed time and date is suitable for her. Let us finalize everything tomorrow. I'll brief you in person in the morning about my impression of the concerns council raised.
Yes,
Right? And then we see on the next page, there's confirmation go down of the meeting. Correct? That will take place at 11:30. Right. Then if we go to page 342, we now switch to the question of, at the same time, around the same time, we're getting go down to the bottom, the judgment in the DAV Cossack matter comes out. 3442.
yes, that's correct.
Go down to the bottom. So the office is currently dealing with the Gordhan matter in May 2019, and on the side, the DA Cossack judgment also comes handed down by Judge Talmay, correct?
Yes, that's correct.
Right. And Mr. Satoli then informs the public protector, the chief of staff, the CEO, and the spokesperson about the judgment. And I'm not going to read it. We went through this email with him, but let's go up to the response. On the 20th of May, the public protector responds and says, it's a build-up failure to PP removal at instruction of PG. Go ahead and appeal the judgment. OPA work with cause and legal to issue the statement about such glaring and embarrassing judgment. Further, the very same provisional report never implicated politicians, exposed the shenanigans in the statement for the public to know the truth.
Yes,
The Talmay judgment was upheld on appeal, correct?
yes, that's correct.
And then if you go to 3445, we'll start at the bottom of the email chain. This relates to a matter brought by a Mr. Mostert. And it regards a Section 7(9) notice issued in relation to an investigation into the allegations of maladministration, abuse of power, and improper conduct by the former Executive Officer of the Financial Services Board, Advocate T.P. Shidi.
Yes,
Correct?
yes, that's correct.
This was the evidence in which Ms. Moghaladi had given before the committee related to this matter.
Yes, the FSB matter.
Right. And there were two applications, the CD application and the application for an interdict, which was initially brought by Mr. Mostert. Correct?
Yes, yes, that's correct.
Right. And this email deals with the Mostert application. In January 2019, Mr. Nemasisi is still the senior legal manager. Correct?
Yes, yes, that's correct.
Right. Now go up. And the PP says, good afternoon. I requested COS to handle the matter. Will advise about the SC to use, but let us oppose the application urgently. You see that?
Yes,
Go
that's
to the
correct.
page earlier. Go up. We'll follow the email chain. I think you've gone to the bottom of the email. And Mr. Satoli informs the attorney of the preferred counsel and an alternative. Go up. The attorney advises that the counsel is not available. Go up. The PPs, Mr. Nemasisi indicates that to the COS that the counsel suggested is not available, give alternative names. Go up. The public protector says, please contact Ngubeni SC to check his availability.
Yes,
Right. I go to 3452. Go to the bottom. Mr. Satoli advises as to the rules of the lodging of an appeal, correct?
yes, that's correct.
And he asks the PP's indication on which counsel we must keep on the matter so he can instruct attorneys to request a memorandum of advice from counsel.
Yes,
Right? And then go up. In the DA Kassak matter, you had two sets of counsel, correct?
yes, that's correct.
The one dealt with the DA application and the one dealt with the Kassak application.
Yes,
The PP then responds to Mr. Satoli's request and says, noted, can you do due diligence about Platt? What does she stand for? Let us consider senior, junior, and junior also, who can fight these with our interests at heart.
yes.
Would it ordinarily be relevant what the advocate stood for?
No, this issue of due diligence is not something, well, not in my experience. We don't do background checks or due diligence about legal service providers.
Go up. Mr. Satoli then says, noted PP, I will conduct due diligence and check credible senior juniors. PP can also indicate any preference on the senior junior.
Yes,
Then go up. The PP then responds, can you send me the Kassak and DA notice of motion to send to Advocate Ngubeni? Did you get the information from Nemasisi about Motimela? I asked Ngubeni whether he can assist the senior junior to prepare papers for appeal.
yes. It comes from the public protector.
And if you look at the invoice that we referred to, if you go back to 24A, Sheppel, the first entry on the 21st of May, go up. receive CASAC DA Vrede judgment and provisional and final PP reports. Final notice of appeal, all DA CASAC papers researched and drafted preliminary argument, 18 hours. Right. If we go back to 3453. We see that Mr. Satauli, although during his evidence, he could not recall Mr. Ngubeni having any involvement in the DA CASAC matter. He addresses an email to the public protector that says, here with the applications by DA and CASAC, I also attach the heads which will assist Advocate Ngubeni in preparing the papers. I'm waiting for Mr. Makaba so I can access Nemasisi's previous office to look for the file on the Motomele matter. People will forgive me because at the time I was not part of legal services. Therefore, I don't have any electronic documents. I will search in his office. At this stage, why would they need to get into Nemasisi's office? Had he left?
Yes, he had left, and I think the files were in his office. Mr. Mukaba was the risk manager or involved in, so it's probably to do get access to his office through security structures in the office.
And if you go to 3455, we see that the PP forwards all the documents. Mr. Van der Merwe, you have a unredacted version. Whose email is that that's redacted in the document?
Mr. Ngubeni. So the PP forwards all these documents to Mr. Ngubeni and says, advocate, find all the below documents.
If you then go to the next page, we then see that the public protector had asked Mr. Satauli to also provide, just go down a bit, just a bit. I'll stop. The public protector had also asked for her affidavit to be provided. And if you go up, you see that she had also, he'd also provided the PP's answering affidavits and heads to both of the matters. Correct?
Yes, that's correct.
Honorable Majority, we have asked them to switch it off. I can see you are unsettled, so it's been attended to. Proceed, Advocate Bauer.
Right. Then at the bottom of 3457, we see an article from Mr. Ngubeni on 23rd of May 2019, where he says, mobilizing the judiciary for political attacks on the public protector. Can justice be done amid efforts to intimidating and remove our public protector? By Paul Ngubeni, and he says, please share with relevant folks and give feedback.
That's correct, yes.
Now, if we go to the annexure, and it's the second entry on the 24th of May, he says, research drafted and published article mobilizing the judiciary for political attacks on PP. Do you see the correlation?
Yes, it's exactly the heading of this article.
Right. Now let's go back to the article. Right. The article relates to the Vrede Dairy project and the judgment of Justice Talmay, correct?
Yes.
And if you go to the last sentence on the paragraph, it says the judiciary heeds the admonition of Chief Justice Mogoeng against allowing themselves to be captured, against the temptation to be celebrity judges, and against being lured by manipulative praises from politicians, analysts, or the media.
Yes.
Sadly, there are exceptions like Judge Talmay, who allows vicissitudes of political controversy. their policy preference is shaped by an amalgam of factors that include their race and, most importantly, ideology or partisanship to determine court judgments they issue. A plethora of legal errors in Talmay's judgment makes it unlikely that an appeal court will ever countenance such a travesty.
Yes.
He was obviously incorrect because the appeal court upheld the judgment.
Yeah,
Is that
they,
correct?
yes, they upheld the judgment.
If you then go to page 3461. It says, Talmay also committed incomprehensible judicial overreach when she found that an exercise of public power is constitutionally invalid, declared the report invalid, reviewed and set it aside, and then claimed that the specific circumstances in this case made it not appropriate to refer the matter back to the public protector. Contrary to the narrative of propagandists, the public protector had not abandoned the Steen investigation. As recently as April 2019, the public protector was busy meeting with emerging black farmers who were meant to benefit from the Vrede dairy farming project as part of an ongoing investigation. This is nowhere in Talmay's biased judgment.
Yes, that's what he said.
And that meetings that took place in April 2019, was that part of the subsequent investigation that occurred?
Yes, and to the
Second
Vrede
report.
dairy project.
He then goes on and says, this ruling is not surprising as Judge Talmay is no stranger to utilizing court judgments to advance populist causes untethered to the Constitution and the rule of law. And then he refers to a 2017 judgment of the judge, correct?
Yes, that's correct.
Was Judge Talmay's name on the list of judges in respect of whom you were asked to find judgments?
Yes, as far as I can recall. As I said, I couldn't check it recently, but as far as I can recall, yes.
And then if you go to the next page, in the middle, it says there is a paradox here. Go down. Talmay, the white paragon of judicial virtue, has had her only significant decision reversed in its entirety by the Concord, but she is white and clothed with the presumption of competence. But in the eyes of the white-dominated Cashsack, the deer, and the self-hating non-white puppets, court rulings criticizing a black professional, such as the public protector, ineluctably points to incompetence or malfeasance, must be career-ending.
Yes.
And so this is an article that stringently criticizes the judgment of Judge Talmay and the judge personally. That be fair?
Yes, very personally, yes.
If we go back to the email to which this is attached, which is on page 3457. We see that this article is forwarded to the Chief of Staff and Mr. Sinego. Go up. The Chief of Staff then forwards this to Mr. Sitauli and to the Public Protector. You
Yes,
see that?
yes,
The Public Protector then gives an instruction to the Chief of Staff and to Mr. Sitauli that says, article is good, he can publish it.
yes. That's correct.
And we've seen from the invoice list that this is one of the items which Mr. Nkubeni sought to add to his invoice, correct?
Yes, absolutely.
If you go to 3464. The bottom. We see there's an address by the Public Protector during a media briefing on May 24 May 2019.
Yes,
And the media briefing is there.
yes,
The PP from time to time gave media briefings when the reports were being issued, correct?
yes. It's usually done on a quarterly basis. It started with Advocate Madonsela and it continued with Advocate Nkwebane, where the reports would not just be issued to the parties, but would be released during usually a quarterly media briefing where all the reports are covered.
And if you go up on this email, we see an instruction from the public protector. Opa, please get the signed Carol Bauer report. I changed it, asked copy from Ephraim and corrected the Prime Minister's one. I will read from the fact sheet. I suggest you include some comments about further judgment, interpret versus apply. Also use Advocate Nkubeni article.
Yes,
And this is the same day on which the article to which we referred was forwarded, correct?
yes.
There's a Prime Minister here. Who's the Prime Minister in the email? We don't have that in South Africa.
Mr. Van der Merwe, do you know what the reference to the Prime Ministers could be?
No, I think Prime Ministers means we usually had anchor reports. And I think it might be primarily or prime, the prime in the sense of the chief or the primarily ministers one. So I don't think it refers to the position of a prime minister. It would have been referring to one of the reports that dealt with a minister.
Right. So just take a step back, Mr. Van der Merwe. What is an anchor report?
An anchor report, usually when there's a media briefing, they select one or two reports of public interest, or that would be the prime report or the main report that would be released, and on which they would focus, the PP would focus in terms of attention. It might be an EMEA, Executive Members Ethics Act, or a service delivery. It's the theme and what I want to highlight during the media briefing. And the rest of the reports would either be supportive thereof, or it would be of equal importance. But an anchor report is basically the report towards we were working to for releasing during that media briefing.
Right. So when you read that, you don't read that as Prime Minister, but more like the central report relating to the ministers she will read from the fact sheet. Is that what I understand?
That's my understanding too, yes.
Thank you. Now understood. I follow.
Thank you, Chair.
Right. Then go to page 3501. Sorry, 3502. Let's start from the bottom of the emails. We actually dealt with it earlier. This was Hoffman's complaint to the LPC, and then go up. We see Mr. Nkubeni's response, and then go up. We see Mr. Satauli, who was tasked with drafting a response. And we know that the 22 July 2019, he says, afternoon, OPA, please find attached the document for the Prof and Kim. So Mr. Satauli is in possession of a document that has to be provided to the Prof. Presumably that's Prof Siepi, and Ms. Halle has discussed in the meeting. And presumably Mr. Satauli is present in the meeting for him to be aware of that. Would that be a correct presumption?
Yes, that would be a correct presumption.
I tried to put out the contrasting factual and legal findings in summary. As I have not yet finished reading the entire judgment, I propose to the team that this document becomes a working document on these contradictions from the justices.
Yes,
It's just the public protector then says to them, then add the background of this matter per cause article, institution under threat, and letter to JP Malambo.
yes,
And she then says, Mr. Satoli says, I'll request the Chief of Staff to assist with the background and litigation history of the High Court.
yes,
And this is in respect of the criticism from accountability now relating to the ABSA CX matter, correct?
yes, from Advocate Hoffman.
Right. And if you then go to page 3505. See that clearly at the bottom of 3505. The judgment from the Constitutional Court comes out, go up, and it's provided to the legal people. It's then forwarded on to the Chief of Staff and the Public Protector for their proposed perusal. And there's then a suggestion for a meeting. Go back up. And go up. Public Protector then suggests that they must summarize key points from the dissenting judgment, and then do the same from the majority judgment with pointers given later, and then go back up. It says, good morning, PP. Apologize for the later response to your instructions below. I was at court for the better part of yesterday, and he then provides the summary of the highlights from the Constitutional Court judgment, correct?
Yes, that's correct.
And the PP then responds to that saying, good morning, Alfred. Thank you for the summary. Let us share as widely as possible. I'm advised you use alliances to do that instead of appearing as if I'm fighting the judiciary.
Yes.
Are you aware of alliances?
No.
Of the Public Protector's Office establishing alliances. Let me rephrase the question.
No. We would have MOUs with institutions that we are cooperating with. But we don't use the phrase alliances with in respect of those. So I would think that it would exclude those that we have formal engagements with.
In your view, is it appropriate for the Public Protector's Office to have alliances?
No, that the risk is that it would compromise the impartiality and independence of the Public Protector, because you would never know when any of these alliances would have to be either the subject or the beneficiary of a complaint to the Public Protector. So it is a risk, and we are compelled to be independent and impartial. So in that sense alone, it is a risk.
So, Mr. van der Merwe, we've worked through the documents to which was referred in paragraphs 5 and 6 of your supplementary affidavit on 418547. Is paragraph 6. If you can just put the supplementary affidavit on the screen. And it would be fair to say, Mr. van der Merwe, that the then appointed Chief of Staff featured quite centrally in these emails that we looked at. Would you agree with that?
Yes, he was copied in giving instructions in most of them.
Right. And you were then asked in paragraph 7 of your affidavit to confirm the dates of the late Mr. Nyembi's appointment.
That's correct.
and we uploaded the folder dealing with documents related to him. Correct?
Yes. Yes, that's
Right.
correct.
And these, you saw some of them for the first time when this was provided to you by the evidence leaders. That be correct?
Yes, that's correct. Yes.
And the first of that documents is attached to your affidavit at 4185.55.
Yes.
If we could just go there, Shepherd. And just, that is dated the 6th of February, 2018.
That's correct. Yes.
Right? That precedes Mr. Niembe's appointment, correct?
That's correct. Yes.
And it's written on a letterhead of an entity identified as Lawyers for Radical Economic Transformation,
Low rate. Yes.
LAWRET.
Yeah.
Right? And this is addressed to the public protector.
Yes.
And it says, "Dear Madam." And it says, "Proposal letter to you dated November 2017. The letter subsequent thereto dated 15 January 2018. And the follow-up telephone conversations between you and the writer hereof have reference." Are you aware of any of those communications?
No. No,
Was
I
it
don't have
discussed
any
at
knowledge.
Manco level at any stage?
No, no, not in. I must also clarify. Even if we are not at Manco, the decisions register is distributed before and after any Manco. So my knowledge would only come from the meetings itself. But if I had sight of decision registers, and I can't recall this being noted there.
Right. And in this, there are certain what's identified as key performance areas in the letter, which appears to be services that could be offered. Go down. Right. And I specifically want to come to the one dealing with litigation matters. And it entails giving special assistance to the legal services department on specific court cases of significance of the PP, attending court hearings and conducting watching briefs. Do you see that?
Yes.
Right. And it also relates to providing media services. Right?
Yes.
He then goes further and he says necessary attributes. Sorry, just before that heading comes, in conclusion, underpinning our engagement with the PP is a need to educate the public on the role of the public protector with a view to ultimately address the risk profile 3 as identified in the PPS, a strategic document, among other things. Right? That
Yes.
PPSA strategic document, it's an internal document, correct?
Yes, it is the strategic plan that the public protector prepares and sign off, or the office in general, and the public protector signs off and then submits it to Parliament and through the portfolio committee as the strategic plan and also the annual performance plan of the office.
Right. Now he then goes on and he says the PPSA operates with justice and legal environment, and he indicates that he has certain attributes: legal training and experience, clear writing and communication skills, and he then goes on to job grading. Go down, next page. He considers the job to be the equivalent of a DG, DDG post, and he estimates entry point at 1.3 million, midpoint 1.5, high point 1.7. He offers his service for the for a long-term professional relationship, a long-term contract for the remaining part of her office, alternatively a minimum period of 3 years with a top-up. And he then
Yes.
suggests, depending on what will work best and convenient for both parties, we can contract in the form of Lorit, the company, or as Niembi SC, the natural person.
Yes.
You see that? Now that
Yes.
SC is not SC as in an advocate. That's his initials,
No,
correct?
it was the late Mr. Nyembe's initials, yes.
Sibosisi Christopher, I think it is.
I
Right.
can't recall the second name, but yeah.
And if paragraph 8 of your affidavit, you confirm that his services was engaged on the 15th of February 2018 as a special advisor for the fixed period of 1 April 2018 to 30 June 2018. Correct?
That's correct, yes.
And then just to complete your affidavit, because I want to go to some documents after this, Wait, Kaap. For the period 1 July 2018 to 31 December, he was not in the employ of the PPSA, correct?
No, that's correct.
He was then appointed as the Chief of Staff on a fixed term employment contract as of 1 January 2019.
Yes.
Correct? And so you then find, as is on CM3, perplexing, that in July 2018, when he was not in the employ of the PP's office, that he would still have a PP address and receive emails from Mr. Ngubeni and sent to Mr. Sinego, to which we referred.
Yeah, because access is usually suspended if the person, either the contract or his employment is terminated. So for some other reason, his email account was still active.
But not only was it active, if you see CM3 to your affidavit, which is at 418558. He is included in the email
Yes.
communication.
Yeah.
And if we look at that email, it says in terms, Attorney Sinego, kindly find my very abbreviated invoice for recent work performed on our recent public protector project. It was my understanding that I would process my invoices through your office. If I'm mistaken or incorrect in any manner, please do not hesitate to let me know.
Yes.
And he then renders an invoice.
Sorry, no, please proceed. Sorry, Chair.
And he then renders that amount that is there, correct?
Yes, that's correct.
We've
Through
looked at the
Mr.
invoice
Sinego.
early on, and I'm going to take you to that shortly. But let me just finish the Mr. Niembi. If we go to bundle F, item 155. It's the 155 in the 50 to 60 category of documents. Right. Mr. Van der Merwe, what was your involvement in respect of the appointment of special advisors while we get the document?
I've got quite substantive historical knowledge, institutional knowledge of the conditions of service and the appointment and the establishment of the public protector, and the more or less the job profiles, and I advise HR on issues that might emanate from time to time relating to the conditions of service. And I recall in January about that year, we had an inquiry about the level of appointment of special advisors, because we are benchmarking against the public service. The first determination by Advocate Backlog was to say that the staff of the public protector would be appointed at equivalent positions or levels of equivalent posts in the public service. So our post structure is generally broadly aligned to positions in the public service, although the post description might differ. Originally, the position of senior investigators, although it's a different position, was that of senior legal administration officer in the public service, and later on state law advisor. So when they were looking at the position of a special advisor, it was not on our structure. So they were looking for the equivalent position in the public service to which we can align or benchmark the position.
And did you know at the time when you did this that any particular person was being considered?
No, as far as I know, there was only the need identified, and that's how we motivated it in the subsequent for the public protector to have a person who's removed from the administration or not accountable to the administration, more independent, but that can advise the public protector on some of the matters.
Okay, and then if we go to a document which is styled as the policy on the appointment of special advisors to the executive authority. But before you deal with the policy, what was your advice rendered in respect of what was required for the purposes of appointing a special advisor?
We found when I did the research, we found that there was no equivalent position in the public protector's establishment, that because the special advisors are appointed in terms of the Public Service Act, and there's a special dispensation for them, because not only is the appointment, but also the accountability and relationship with the administration is removed, because they are not subject to issues like the conditions of the code of conduct, because in the public service, they are usually used to advise the executive authority on party political matters. So their affiliation, they cannot be removed from political aspects like normal public servants, and it's a special dispensation. And the Public Protector's Office didn't have an equivalent position that would provide for such a special dispensation. So basically, there was no position internally that we could benchmark against. And we then recommended, even in January that year, that the Public Protector will have to make a determination in terms of Section 3, 9, and 10 of the Public Protector Act, and submit it like Advocate Backlog had to do many years ago, to provide for the conditions of service and remuneration of the position of a special advisor.
And submitted to who?
In terms of the Act, the PP is required to consult the Minister of Finance, then make a determination and submit it to Parliament, to the Speaker's Office to be tabled in Parliament. The Act only requires tabling in Parliament. Then within 14 days after the determination is made, then it becomes valid as the determination in terms of Section 3 of the Public Protector Act. The Act says the Public Protector may determine the conditions of service of staff members on the establishment of the Public Protector. And that is the process to determine the conditions of service, as well as the remuneration of people on their positions on the establishment of the Public Protector.
Right. And did this take place prior to the letter of appointment being issued to Mr. Nyembe on 15th of February 2018?
No.
2019, yeah, 18.
No. We followed some processes, but it was way after that. We drafted the process. I traced my documents and we've made a draft determination in January of that year. So we did propose it to the powers that be, but at the time it was not implemented.
Right. So if we then, Chair, I'm going on to 4 documents now. Do you want me to continue or do you want to take the adjournment now?
Going to 4 documents.
Yeah. I'd
Okay.
like to deal with them together. That's why I'm asking you.
Okay. And how long do they take?
Should take me 10, 15 minutes.
Okay.
I continue?
Yep.
Okay. Mr. Van der Merwe, we're going to go to page 155, not page 3097, and the document is the policy on the appointment of special advisors to the executive authority. It's item 155 in bundle F. Right?
Yes.
It's dated 14th of February 2018. Right?
Yes.
It's a policy that is signed by the public protector the day before Mr. Niembi is appointed, correct?
Yes,
Or
that's
the
correct.
letter. What was the purpose of this policy?
As far as I can establish, it was to
Sorry,
provide
let me not
for.
make. Sorry,
Wait,
Mr. Van der Merwe. Let me, sorry, we're talking past each other. Can we just go to page 3098? The next page. Okay. Let me ask these questions simply. Did you draft this policy, Mr. Van der Merwe?
No, I think it was drafted by HR.
And the purpose of this policy is to regulate the appointment of special advisors to the executive authority, correct?
That's correct, yes.
And if you go to paragraph 4, the need for the special advisor is identified that it's based on the public protector having wide powers, is expected to deal with matters efficiently as effectively. And if you go to 4.3, for that purpose, she's requested to have high-level specialist advice on each matter as identified. You
Yes.
see that?
Yes.
Since Advocate Niembi's passing, has there been another special advisor appointed?
No special advisor appointed.
If we go to page 3081, sorry, it'd be item 153, and that is simply the appointment letter of Mr. Niembi dated 15th of February, which confirms his appointment. Shep, I don't think we need to go there specifically. It is there, let me just identify it. And then if we go to 3108. No. Sorry, Shep, it's 3092, item 154. 54. Item 154. There's a memorandum dated 24th of May 2018.
You said 3092. Oh, wait, do we have such a page?
Yes, it's in the bundle that items 150 to 160. Got it? There we go. So you might as well open the others. Right. So this is a memorandum that's sent to the CEO from the Senior Manager Legal Services, Mr. Nemasisi. Go down. Right. And this takes place in May of 2018.
Yes.
Right. And it's legal advice on the appointments of the Chief of Staff and the Special Advisor.
Yes.
Right. And the reason for this is articulated in the first paragraph It's to advise the CEO about the process to be followed subsequent to concerns raised in the bargaining forum and media queries regarding the appointment of the special advisor and the chief of staff.
Yes.
Now, Mr. van der Merwe, this committee had heard evidence from Mr. Samuel and Mr. Kekana that the concerns had been raised in that period in respect of the appointment of the chief of staff who wasn't properly qualified and the special advisor who wasn't lawfully appointed. Would that be correct?
That's correct. Yes, that's correct.
And this memo talks to that.
Yes. And the bargaining forum is the internal collective process between the union or organized labor and office.
And those at the public protector's office who were the union representatives would include those like Advocate Isaac Matlawe, Mr. Tebogo Kekana, and Mr. I think I stand corrected. I'm not sure if Mr. Samuel was one of the, but the two in the, Mr. Radani indicated.
In the Cheney, yes.
That's correct. Right. And then if we see on 3093 of the document dealing with the chief of staff, who was the chief of staff at that stage?
Ms. Maluleka.
And the issue was the fact that Ms. Maluleka did not have the qualifications, correct?
Yes, that was the concern.
Right. And was that correct that she did not have the requisite qualifications?
As far as I can recall, we were requested to provide that, and in response to media inquiries and in response to a request from the union, and the office, as far as I am aware, could not produce any post-matric qualifications. There was something about the secretarial course, but yes.
Right. So then if we go to 3.14, Mr. Nemasisi advised that although the prerogative to appoint the chief of staff lay with the public protector, the person still required minimum qualifications. And he records in the next page at 3143 that the appointment is invalid and must be terminated with immediate effect.
Yes.
Correct?
Yes.
When it came to the issue of a special advisor, he referred to the policy to which I had referred you. He referred to the provisions of the Public Protector Act, indicating go down that the special advisor was not part of the staff complement, and essentially explained the process of the Minister of Finance that you had referred to. And then at the bottom of page 4, he concludes, due to the invalidity of the policy on appointment of special advisors to the executive authority, the appointment of the special advisor must be terminated with immediate effect and the normal process prescribed must be followed.
Yes.
Did that occur, Mr. van der Merwe?
Yes, I think Mr. Inyembe's contract was subsequently terminated.
Well, actually, his contract was for 3 months. He saw his contract out, Mr. van der Merwe.
That's right.
Right. In fact, if you turn the page at 3096, he says the chief of staff's appointment is linked to the public protector's term of office. The special advisor's contract is coming to an end on the 30th of June. That's 1 month more salary compensation, and it may result in fruitless and wasteful expenditure. And it's then recommended that there be some negotiation with him so that they don't risk the dignity and integrity of the public protector and the office for their personal right? For their
Yes,
personal interest.
yes,
What happened?
that's correct.
What happened to Ms. Maluleka?
She returned to her original position or another position, I think, in customer services, because she was seconded to that position in the private office, and she just reverted back to the establishment of the public protector, the administration part, or the head office part.
And notwithstanding the advice provided by Mr. Nemasisi, external legal advice from counsel was sought, correct?
Yes, and the fact that we already advised on the process in January of that year.
And if we go to item 161-3129. Mr. Satauli then asked me, Mr. Senego, to obtain urgent legal advice to be finalized to the CEO in 7 June 2018 in respect of this matter. And if you go to 3132, go down, we see that there is then a draft letter of consultation that then is sent to the Minister Neni about that, right? And if you go to the next page, we see that 2.4 and 2.5 of the letter indicates that there was a letter from Treasury. Are you missing a page? Okay, we'll sort that out. Right. There's a page missing in this, but the paragraph reads, the public protector received a letter dated 5 June from the National Treasury. The letter requests the public protector to withdraw the policy on appointment of special advisors on the basis that the public protector did not consult with the Minister of Finance when implementing the policy as required by section 3139 and 310 of the Public Protectors Act. And then the instruction is given to Senego to brief a senior counsel and request a legal opinion.
That's correct, yes.
Right, and they provided with documents in respect of that, and the legal opinion that comes back essentially doesn't say anything much different. Would you agree?
Yeah, it confirms the process as we had advised on.
Right, we'll deal with the cost of the legal opinion later. Right, there's then correspondence with the portfolio committee, which we see at 152 in respect of that matter, which we don't need to go further. And subsequent to that, Mr. Niembi is appointed as the Chief of Staff in January of 2019.
19, yes.
Now, if we look at 3104 of bundle F,
It will be the last document.
that will be the last one.
Thank you.
161.
Load saber. Okay.
Sorry, it's fine. It's the CIPC document, which shows that Mr. Niembi was the sole director of the legal entity called Lawyers for Radical Economic Transformation. I'll give the page reference after the lunch adjournment. Chair, is this a good time to take the adjournment?
Thank you, Advocate Bauer. Thank you, Mr. van der Merwe. Colleagues, we pause now. We'll be back exactly at 2. We'll take a lunch break. Thank you.
Recording stopped.
Thank you, Chair.
numbers is the Adobe Acrobat references, because the documents for purposes of convenience were pulled together in one folder, but are found at different places in the record with different numbering. So it's just to see if we can stop the jumping around a bit, that I've pulled it together. So the first document, Mr. Van der Merwe, if we see the date, that's the 29th of June, 2018. Correct?
That's correct, yes.
That's the first instruction letter that we found going out to Senegal attorneys, correct?
Yes, that's correct.
And they were engaged to assist the public protector in preparing the submission to the Portfolio Committee on Justice and to represent the public protector on the inquiry into a fitness. This related to the complaint that then had been lodged by the previous chief whip of the DA, correct?
Yes, that's correct.
Right. Right. And if we then jump a bit, if we go to file 125, page 18, which would be 513 in your bundle, Mr. Van der Merwe, right? Will just be a few pages on. I'm skipping through some of the other pages you would have,
Yes,
right? We see that this is the bill for purposes of that submission to the Portfolio Committee on Justice and Correctional Services, correct?
yes, that's correct.
And effectively, what we will find from this bill is approximately 25 hours being spent on looking at the documents and perusals of the letter, or the drafting of a letter, correct?
Yes,
And we see that total coming to 206,000 on the next page, being 514 or Adobe 19. And attached to that invoice is the invoice headed Advocate Paul M. Gabeni, which is the next page,
yes,
correct? And we
that's
see
correct.
that he too spends between the 2nd of July and the 4th of July, 13 hours on drafting a response for the public protector together with case law and the rules, correct? And then
Yeah.
we find, sorry, I'm going very quick. Just tell me if I must slow down, Mr. Van der Merwe.
No, I'm with you, Chair.
Right? On the next page, we see the counsel on brief, perusing of the files and the drafting of what could only then have been the letter is another 44 hours,
Yes,
correct? And then
that's correct.
we know that that comes to 206,000, and that the bill was submitted to Mr. Sitauli, correct?
That's correct, yes.
Now we turn to what would in your file be the email dated the 19th of September from Mr. Sitauli. For you, it would be item 165. It's the page which was initially marked 3513, but it's marked 3534 in your documents, Mr. Van der Merwe.
Yes, I've got it.
Got it? Right. And then this is an email which Mr. Sitauli writes as an instruction, correct?
Yes,
And he refers to a telephonic conversation with Mr. Sinego, and he says, consider the contents of the below article and the attached initial draft letter for your settling. You see that, Mr. Van der Merwe?
yes,
And this is one of the articles that Paul and Gabeni produced, correct?
yes, that's correct.
Right. And you saw that from correspondence which was provided you, which lists Mr. Gabeni's articles.
That's correct, yes.
You are requested. That's right. You are requested to paraphrase the letter to be as near as possible to the contents of the article.
Yes,
We attach here to our rates to assist you in preparing the invoice.
yes,
And then attached to that is at 165.1, 3535 is the 7-page draft letter to the speaker. Correct?
yes,
And attached to that is the tariffs that is then provided. Seppo, you don't need to go to the tariffs, right? Which it is at
Yes, that's
160.
correct.
Or maybe just go down while you are at the tariffs. That's the tariffs of fees for attorneys approved by Mr. Tembalamini. He was the previous CEO, correct?
Yes, that's correct.
Let's go down. That was approved in May 2017.
That's correct.
And they're usually in effect for 3 years. Would that be so?
Yes.
The next document would be F-125 9, which would be 2749 in your bundle. Sorry, it would be the next page. F-125 9. I'll make it 10. Yes, it's 10. Right? It's headed submission to the Portfolio Committee on Justice and Correctional Services.
Yes.
That's consistent with the instructions given to them, correct?
And the letter of appointment, yes.
And the letter of appointment. Now, if you look at the first entry, it says prepare and send an email to Mr. Nemasisi regarding the possibility of applying to court for a declaratory order which may clearly define the rights and obligations of the public protector.
Yes.
That's not submissions to the Portfolio Committee, correct?
Yeah, that was not included in the original brief.
And if you go down to the bottom, you see telephonic discussions with Advocate Manke and Mr. Ngubeni for a draft legal opinion and comments,
Yes.
right? And if you turn the page, then you see there is a legal opinion provided to
Yes.
the tune of 100,000, and Mr. Sienego amends this legal opinion, conducts further research, and finalizes this opinion. And in fact, he's assisted by a candidate attorney who does it as well.
Yes.
Correct? Right. And we know from Mr. Katoli's evidence that he approved the payment of these invoices.
Yes.
If we go to Annex to CM3 to your supplementary affidavit, page 4185.59. We see that by March 2019, Mr. Ngubeni seeks payment of his fees from Mr. Sienego, and he includes Mr. Niembi in the email,
Yes.
correct?
Yes.
And if you and he's seeking payment of his March 2019 fees, right?
That's correct.
And if we go to F-125, page 26. Go down. We see that Mr. Ngubeni's fees is in the amount of 87,000 Rand, and the heading is Tito Mboweni.
Yes.
We had, as you'd be aware, reversed the bill from Mr. Ngubeni at length, dealing with media articles and advisors in respect of that matter. So I'm not going to detain you with that.
Okay.
Correct? Mr.
Yes.
Satori also confirmed that he approved payment thereof. Correct?
Correct.
Right. Then if we go to your Annexure to your affidavit 418560. It's an email from Mr. Ngubeni to Mr. Senego, as well as to Mr. Nyembe, and he says, attached is my invoice as discussed. I'm aware that an opinion may be priced differently, but not necessarily paid on the basis of the number of hours. I remain flexible and will accept reasonable amount as determined by the client, even if that results in downward adjustment. There can be no doubt that the client here is the Public Protector's Office, correct?
That's correct, yes.
Right. And if you turn the page, you see an invoice, or what passes for an invoice for the purposes of an opinion that is rendered for 48 hours, which comes to 96,000,
Yes, that's correct.
right? And if you go separate to page 1 of F125, and you turn the page, Mr. Van der Merwe, you see a statement for the Tito Mboweni invoice, and it says offer to appoint to act on behalf of the Public Protector in the provision of a legal opinion from senior counsel in the amount of 165. And if you turn the page on that, you'll see the invoice that shows Mr. Ngubeni's fees for 96,000.
Yes,
And we know that this is the opinion in respect of the CR17 matter that was provided on a Senego letterhead as traversed with Mr. Sitauli. Do you recall that?
yes,
Right. Now, if we go to F161 again, and we go to page 3297. Right. Here's a tax invoice that says defamation, Palais and Lochenberg. Correct?
yes,
And it deals with a letter from Weber Wenzel in the amount of 8,750.
yes,
We had earlier this morning seen Mr. Ngubeni also wanting to bill for 4 hours dealing with the Weber Wenzel defamation matter.
yes,
But that's not reflected on the Senego invoice.
no,
You see that?
no,
In fact, we've come across no invoice where Mr. Ngubeni is, other than the one that we know wasn't paid, is again reflected on an invoice for work, for this work rendered.
yes,
Agree?
yes,
Right. Now, if you go to your affidavit, SEPO, it's 4185.62. (8562). No, not the affidavit, the annexure 2482. Go down. We see an email from Mr. Ngubeni on the 30th of August. And he provides it to Mr. Senego. He asks for prompt payment. And if you go up, we see Mr. Senego then sends it on to the legal people and Mr. Nyembe, correct?
that's correct, yes,
If you turn the page, that's the invoice for August the 1st to August the 30th. And we see here is the bill for the draft response to Advocate Hoffman, the draft appeal argument in the Gordon versus Public Protector matter, the rogue unit, the answering affidavit in the Lordlo matter, and correspondence with Advocate Masuku, 70 hours.
yes,
At what we know, Mr. Ngubeni's rate to be at 2,000, Have we come across an invoice of 140,000 from the senior to be paid to Mr. Ngubeni?
No, not to my knowledge, not that I can recall.
If we then go to F161, $3,398. We go down. And there's he's writing to inquire about payment of his July invoice. And he makes a point of indicating, as previously requested, the invoice reflects work of several months, and I've explained my special circumstances. He requires prompt payment. And this is then, if you go up, forwarded back to the public protector's legal people.
Yes.
Right. If you then go to 3399, go down to the bottom. We see Mr. Shatswayo, who we know to be the sole director of Visconini, right? And he says, Kim Heller had asked me to send you an invoice that was sent to Paul last week. I've attached an invoice to this mail. Go up. And it's, by the way, it's directed to Dear Theo, correct?
Yes.
So it's quite clear that Ms. Heller knows that the invoices is going to Sienego Incorporated, correct?
Yes, that's correct.
Right. In fact, there's an email that follows on that that says, Dear Theo.
Yes.
You've got a clear copy of that. Who's the sender of that email?
Ms. Heller.
And it says, Dear Theo, I hope you are well. This invoice is for communication services provided by Prof and I over the course of July, August, and September. The amount is less than contracted as we've based it on direct hours work. We're due to meet today with the office, but it's been rescheduled. I'll provide you with a report on impact of articles, posts, and other interventions. Right? And that's the
Yes.
invoice 002 that we know to be 170,000, correct?
Yes.
120,000.
120,000.
And we see go up. That is then forwarded to Mr. Mashlungu, Mr. Satauli, and Mr. Niembi.
Yes.
And so all of them would be aware of the work being rendered by Ms. Heller and Professor Siepi, correct?
That's correct.
And then if you go to page 3432. That's Mr. Nkubeni asked, here, Mr. Sienego, may I kindly have a prompt response to my previous queries which have gone unanswered. It is quite unsettling that I must repeatedly nag folks or lobby each time just to get my invoices paid. On 30 August 2019, I sent my invoice and about 2 months later made a follow-up inquiry, never responded to me. You kindly respond with clear indication of when I get paid. Have you found any reference subsequent to November 2018, 18th November 2019 in the Sienego invoices on which Mr. Ngubeni is paid for the work he rendered?
No.
If you go up, you see that that's forwarded to the legal people. Chair, for the record so that it reflects, we addressed correspondence to Mr. Ngubeni asking him for information. The committee has that correspondence, as well as Mr. Ngubeni's response. He not without some justification indicated that our questions were compound questions and convoluted. And if we asked a simple question, we would get a simple answer. Taking that on board, we redrafted the questions. We sent it to Mr. Nkubeni, appreciating that our questions may have been complicated. And we'll put that before the committee once we get an answer to the questions in that regard. We've also asked him for certain documentation so that we're quite clear as to how this got paid. On the record, we currently do not have a reflection of the payments made by Mr. Nkubeni to Ms. Haller and Professor CAP. If we now,
Thank you. We'll await that and watch that space.
Mr. Van der Merwe, we then turn to your main affidavit, which is at 464060 in bundle D of the bundles. It's item 24. The affidavit is item 24 and the annexures are the sub numbers 1 to 18. Included in the bundle was 2 revisions of 12 and 17 and the summary of judgments to which we will also refer to. Mr. Van der Merwe, I want to pick up the affidavit at paragraph 6 of the affidavit. Right? And the committee will recall that during the course of evidence of Mr. Kekana, a document was referred to, an incomplete draft headed Public Protector's Observations on Constitutional Principles Applicable to the Independence and Governance of the Reserve Bank and Proposals for the Review. And it was presented to Mr. Kekana during his evidence of the committee. Are you the author of this document, Mr. Van der Merwe?
Yes, I am.
Right. Now you deal with this. This is the document that's at bundle H, item 3, page 3. Is this the document, the correct document?
Yes, that's the correct document.
Now, from paragraph 8 onwards of your affidavit, you deal with this with reference to the annexures, right? Can you perhaps take us through the background to how this document came to be created?
Yeah, it was not long after the Public Protector assumed office in December 2016 that I received an email. By that time, she was already acquainted with my role as institutional knowledge and providing research. And she asked me for an update on outstanding tasks that I was involved in relating to the amendment of the Public Protector Act. We were preparing proposals for the Department of Justice, the finalization of the Public Protector rules, transmit matter, which was a report. And then she needed a paper on the Extension of Security of Tenure Act, where we were going to make a presentation to the Portfolio Committee in Parliament, and then refer to a proposal on the amendment of the Constitution, both in relation to land, as well as full control of the central banks. With regard to the Constitution, I wasn't fully, I didn't have the background, because I suspected that this emanated from a dashboard or an internal discussion where certain decisions were taken, and that decision, the resolution, was not conveyed to me. It wasn't raised in think tanks or any of the other internal meetings. So I sought clarity on it, and I waited for instructions. Mr. Nemasisi and I were going to deal with it together. But then, a bit later, the then CEO, Mr. Dlamini, called me to his office, and he handed me a document which was, he said, was a private member's bill, which he said that the late Mr. Mario Oriani Ambrosini MP made to Parliament in relation to certain proposed amendments to the Constitution. And he requested that I prepare a submission to the Constitutional Review Committee on behalf of the Public Protector based on the bill. The brief was that the Public Protector wanted to endorse this private member's bill as a submission to the Constitutional.
I think I interrupted you. I just want to keep the members up to speed with the documents as you go along. The email to which you referred, from which you got the initial instruction from the Public Protector, is annexed to your affidavit as NV1 at 4,100, and its contents are repeated in paragraph 8 of your affidavit. That's correct?
That's correct, yes.
Right. Then in paragraph 11 of your affidavit, your request for the submission to the Constitutional Review Committee, it wasn't uncommon for you to make submissions to the Constitutional Review Committee. Is that correct?
No, it's part of my normal functions to do legal research, my submissions on legislation or even concept papers for the executive authority and the leadership.
And as you just indicated, you were given a draft bill and you were told that this was a private member's bill.
That's correct, yes.
And the CEO at the time was Mr. Tembalamini.
That's correct.
Right. And that bill that was provided you is annexed to your affidavit at NVM2. Correct?
That's correct.
Right. And if I get that put on the screen, that is at page 4,101. Correct?
Yes, that's the document.
Right. So now just tell us, we'll talk a little bit about, pick it up again from where you left off when I interrupted you. Sorry, Mr. Van der Merwe. I'm going to interrupt you so that we can keep track of where we at in this.
Yes,
Paragraph 12.
Yes. I then started to look at the bill, the content thereof, and with the brief in mind that we were going to endorse this as a submission to the Constitutional Review Committee for the review or for the amendment of section 223 to 225 of the Constitution. But then when I did the research and I also looked at the context, the first thing I wanted to check is what happened to the bill, if it was indeed submitted by the late Mr. Ambrosini to Parliament, and if it were ever ever put on the papers or the agenda, and so on. And then when I checked the source of the bill, I found that it was actually not drafted by Mr. Ambrosini, but it came from a book from a certain Mr. Stephen Mitford Goodson called Inside the South African Reserve Bank, Its Origins and Secrets Exposed. It was a 2014 book. And I then addressed an email to Mr. Nemasisi because he was the co-worker or the co-author of the submission to the Constitutional Review Committee, where I wanted to share my concerns with him about, first of all, the impression that we had that this bill actually came from a member of Parliament, while that was not the case, and then the contents of the bill in itself. And also Mr. Goodson's background raised certain red flags for me, which I felt I should raise with him. And I alerted him to what the bill proposed in terms of the Constitution, that Parliament shall have the sole power to issue money in any form, which will be interest and debt-free, The amount of money is decided by a monetary trusteeship, which would be 7 to 11 individuals to be appointed by the National Assembly, that they will meet once a month to exercise duties and have the cooperation of the Minister of Finance and a state bank called the People's Bank. And the Minister would issue directives to the monetary trusteeship, and amounts will be monitored against price index computed by Stats SA. That new money will be paid into, this is the wording of the bill, into the economy by Treasury and withdrawn. The withdrawal will be achieved by temporary taxes. I was asked to check if it would be possible to use these principles as a basis for the amendment of the Constitution. In addition to the amendments to the Constitution, there was draft legislation which was called the new proposed Monetary Reform Act, providing for basically the nationalization of the money supply, but not the banking system, and will include provisions that all banks would hold 100% reserves, the retirement of the national debt, permanent stabilization on the money supply, the establishment of a monetary trusteeship, and withdrawal from all international banks and related agencies such as the IMF and the Bank for International Settlements, and the establishment of a foreign exchange stabilization fund. According to the drafters of this proposal, it would mean the abolition of income tax and a reduction of VAT, zero inflation, termination of what they termed business cycles, full employment, eradication of unemployment due to a massive public works initiative, budget relief, housing loans at a zero rate interest, housing for the entire population at a 5-year period, and the rapid implementation of what was called the contribution philosophy in order to expand community projects and de-urbanization. I pointed out to
Mr. Van der Merwe, you detailed this in the email to Mr. Nemasisi, and that is located at 4106 of your affidavit as NMV3, correct?
That's correct, yes.
Right. And then in paragraph 3 of this affidavit, which is copied in your of this email, which is then copied in your affidavit, paragraph 14, you state the following in the email. Can you just read that to the committee?
Yes, I said to him, I do not mean to question the instructions from the PP and the CEO, because remember the CEO said that the PP wanted to endorse this to the Constitutional Review Committee. I said, but apart from the concerns about, and I highlighted apart from the concerns about the content and the implications of the amendments, because we were not, sorry, let me first just read, that we would be, apart from concerns about the content and the implications of the proposed amendments that we would be endorsing, I established that the draft proposals were not compiled by Dr. Mario Riani Ambrosini, but is actually the political manifesto of a party called the Ubuntu Party, who contested the general election in 2014, but only managed 8,000 votes. Afterwards, they accused the ruling party, the ANC, of election fraud. The Ubuntu Party intended to submit a draft legislation as a private member's bill if they managed to get representation in the National Assembly. Apart from my concern that we would be endorsing, or that our endorsement of the draft would effectively amount to support of a political agenda of a specific party, there are other more significant reasons why such an endorsement might constitute a huge risk for the public protector. See the document includes why do we need banking reform. And can I proceed, Chair?
Yes, you may. Sorry.
I
You
also
then
then showed,
highlighted the author of the book.
yes. I then highlighted that author, Mr. Goodson, is both the deputy leader of the Ubuntu Party, but he's also a former director of the South African Reserve Bank who left the Reserve Bank under a cloud of controversy as a result of his support for what was termed the Nazi economy and banking system, which was presumably the basis of the proposed amendments. I referred to certain articles in the media, in the public domain in the media, where it was reported that Mr. Goodson held contentious views that included admiring the economic policies pursued by Hitler in Nazi Germany and a belief that international bankers financed and manipulated the war against Hitler because they saw his model of state capitalism as a threat to their usurious ways. I also pointed out that other countries like the Israeli Public Affairs Committee had some problems with him. And basically, because he was a Holocaust denialist and adherence to anti-Semitic Semitic hate speech and falsehood. And the matter received widespread media coverage. And I also included copies of the media articles. And irrespective of whether these allegations were true, it was, in my view, problematic. And as I said, I was hesitant, but because I had specific instructions, but I felt that by just endorsing it, it would create a risk. And I specifically said to Mr. Nemasisi that I feel I would not be doing my duty to the public protector and the institution if I don't deal with this and not raise the fact that in the circumstances I'm concerned that the endorsement of the proposed legislation prepared by the Ubuntu Party and Mr. Goodson might pose a high risk for the public protector, particularly in view of the fact that she was under close scrutiny by all parties.
Mr. Van der Merwe, can I just interrupt you at that point?
Yes.
When you were employed at the Public Protector's Office when Advocate Nkubani was employed there previously?
That's correct, yes. Yes.
And so you knew her from a previous employment?
Yeah, a long time.
And what was your view when she was appointed as Public Protector?
We at the office were very optimistic and positive, first of all, because we knew her as a colleague. And at the time when Advocate Madonsela's term ended, there were a number of internal, I would call them HR and issues that, you know, people would always have expectations and the focus was different. So the first expectation was that Advocate Nkubani knew what knew how it would feel like to be a staff member, and on the internal resources would be a priority for her. That she would focus on issues like the employer relations. And
you got cut there. You're cutting.
relations.
I don't know whether you have some challenges there. You're frozen now.
And I remember meeting
Mr. Van der Merwe. Mr. Van der Merwe. Yes, I think he's now properly frozen. Just give a few minutes for that to be attended. It's been okay so far. It might be affected by some network issues. Let's give it a few minutes, colleagues. Maybe just 2 or 3 minutes until it's sorted out. Tebingosi, you can check him in the meantime. He's there next to you in the air. He got kicked out. Please, accept him back.
All right, Chair, he will be rejoining now. He lost connection, so he's going to be rejoining now. Thanks.
Thank you. That also helps so that we can see you also still here.
Recording stopped.
Well, we did not say stop it. You can record the silence. Thank you. Mr. Ngoma, is he traveling far to join?
Okay, he is in the waiting room, Chair. I'm letting him in now.
Recording in progress. Recording stopped. Recording in progress.
Mr. Van der Merwe, can you hear me? Can you hear me, Mr. Van der Merwe? Okay, I see your lips are moving, which means you are talking, but we can't hear you. Going to suggest that you go out and join again so that you get into the voice issue. Your mic is just not audible. Just go out and join properly again. It's the quickest way to do it. Gaan maar uit, dan kom je terug in. Dat is beter. Log out and log in again.
Good afternoon, Chair. Can you hear me?
Now we can hear you. So it was the machine that you did not switch on. We had lost you and you got cut and then got frozen. So we just want to pick up where we left. Can you hear me? No, save here. There's something there that you are doing. You are muting yourself, not on the, I think it's just your own system, because we just heard you now.
Chair, he's requesting that we give him a few minutes. He's gonna have to change devices He tried logging on now, but you couldn't hear anything from your side. So he's going to try and change the device. So he's asking for a few minutes. Thanks, Chair.
Thank you. Just go and help him.
I'm in
You're
Cape
all
Town.
up in the air. You're all up in the air, you know, just in the space.
Recording stopped.
Yes, you can stop now.
Good afternoon, Chair. Can you hear me now?
Mr. Cornelius van der Merwe, yes, we can hear you. Are you back now properly?
Thank you, Chair. Yeah, I switched to a mobile device, to a mobile network.
Recording in
because
progress.
It
Thank
said
you.
our office network was unstable.
Oh, okay.
Sorry about that, Chair.
Yeah, you did break out and it got frozen. So I'm going to ask Advocate Bauer to just take you where she needs you to be so that we can hear everything else.
Mr. van der Merwe, you were telling us that there were certain HR issues in the office. You
Oh, yes.
were enthused by the appointment because you understood that she had come from an employment background at the PP's office and she would have an understanding about it. Is that a correct summation of what you saw to relay?
Yes. Yes, as I said, there was a sense of optimism internally about the relationship. And generally also, as I said, because one of our own made it back to the office as the head of the office. So there was a general sense of optimism and welcome to the public protector, and even me personally. We've always had a good relationship.
So, and you continue to have a good relationship throughout the tenure in office?
Yes, yes. The public protector I always felt like a valuable member, and I was able to contribute to the office, and that the institutional knowledge that I had was valuable on various aspects. When in the FISD context, we were dealing with other Chapter 9 institutions, with the engagements with the Commission on the remuneration. Yeah, we've never had any issue in terms of the work or any relationship problems.
So, sorry, I interrupted you. If we then go back to paragraph 18 of your affidavit, you had stated in paragraph 17 that you had raised it because of the risks involved to her, and you were aware that she was under close scrutiny by all parties at the time, correct?
Yes, that's correct.
Right, but you also point out in paragraph 18 that before sending this email, you were mindful you were not an economist.
That's correct, yes, because like all the subject matters that comes to us, we try and do research as much as possible, but these are very highly technical, and I acknowledge the fact that it comes from experienced people. So whatever I had to deal with, I had to acquaint myself with the principles, and that it was always from a legal perspective that we were dealing with these matters and not from an economic perspective. But we sorry if I can. We then proceeded to draft an presentation or a submission to the Constitutional Review Committee, basically developing an alternative line based on a need for oversight. We wanted to take just some of the principles we felt was good, like on the governance base, and also based on the highlights of the Constitutional Court matter in the role of the National Assembly or Parliament over institutions like ours. I felt similarities could be extended to the Reserve Bank and linked to that, and see if we cannot propose that as an alternative basis to still propose amendments and improve governance and oversight over the reserve banking, as opposed to the idea of a national bank as such. And I prepared a draft, and we also in that draft, and that was what the CEO said to me at the time, we just must then alert the committee to the fact that there are alternative views like those of Mr. Goodson. Even if we don't endorse it, then just to alert them to the fact that there are these views out there. And I prepared a draft, which I enclosed to my email that was sent to Mr. Nemasisi.
And that draft is attached to your affidavit as NVM 4114, correct?
That's correct, yes.
Right. And if we go to NVM 3, and I just want to take it from the bottom up. Yeah, it would be NVM 3. Right, and we go to page 411. 41111. At the bottom. Okay, at the bottom email. Yeah, it's Mr. Nemasisi tells you he's not involved in the matter initially, but the concerns you raised in your below email are very serious, and I suggest we have an urgent meeting to discuss your concerns with the CEO and the public protector. I await the directions of the CEO.
That's correct, yes. Yes.
Right. And if we go up, you then email the CEO and you say, I'm sorry to bother you, but I was wondering if you had a chance to look at the issues raised in the emails or to consider the draft submission, excluding the potentially controversial draft legislation proposed by the Ubuntu party. And if we go to the next page up, we see the CEO ask the public protector, dear PP, I need PP's approval that we make the submission as proposed by Niels. The attachments of Ubuntu party and change to the South African constitution are for PP to note, but also to acknowledge the envisaged risk if we opt to support the manifesto of a party, which was included in Mr. Goodson's book as draft legislation. We are in a better position with the submission without relying on Goodson's book. Go up.
That's correct, yes.
All right. The public protector then answers on the 7th of June and says, I'm aware about Niels's concerns. Can he propose how we can amend the constitution to have state bank and parliament to oversee the state bank?
That's correct, yes.
And then there's a response to that that says, I will meet with Niels and Mr. Nemasisi to discuss PP's concerns, right? What
Yes.
then transpired?
Now, we
Mr. Van der
didn't
Merwe?
have a meet. We didn't have a meeting, but on the 6th of June, I then started the research, which culminated in that draft document that you reflected. I did extensive research on the issue of a state bank comparatively with other countries, and on the principles that I thought the PP would be highlighting, and how we thought, because the whole aim of this thing was to motivate a review of sections 2 to 3 to 2 to 5 of the Constitution. It didn't even come to the point of having concrete amendments in mind, but just to deal with what we can support and what we can endorse in view of the background to the matter. And And then,
If I take you to paragraph 19 of your affidavit, which is on page 470, were you aware at the time that the PP had met with Mr. Goodson?
no, the first time I read about or that I encountered Mr. Goodson was in the research. And then later on, even after the CIX matter, I then saw tweets or something where the PP said his book was a good read. And then only I learned that she actually engaged him and had a meeting with him during the CIX investigation.
Right. Now, at the time you were working on submissions that you were going to submit to the Constitutional Review Committee as part of your responsibilities, correct?
That's correct, yes.
And how did that work fit into the CX report?
No, I wasn't even thinking about the CIX report. I had no knowledge or suggestion that it was for the purpose of crafting any kind of finding or audit, because usually in an investigation you would deal with the legal framework in the context of that investigation. And this did not relate to the legal framework in my view. I didn't even think it would be informed or endorsing the whatever legal framework was governing the CIX report. I wasn't even at that time fully aware of what was the and until I got to the actual inputs to the report, where we were supposed to have a mini think tank, but that would come in later. But at that time, CIX was not in my scope or thought process.
If you go to paragraph 25 of your affidavit, having dealt with the previous paragraphs in your answer to the, you then say, in an endeavor to meet the PP's aforestated request, you embarked on this research, which you told us about, and you commenced drafting that paper. You didn't have a deadline for that paper?
No. It might have been that there was a deadline for the Constitutional Review Committee. So I know I dealt with it as a matter of priority, but I can't recall any deadline because I was still busy with it. Later on, it was not finished.
And then the CX report was issued on the 19th of June 2017, and you say it created the furor. Tell us what that was.
Yeah, the first reaction was there was the rand fell and there was losses, and everybody was up in arms, the media, about the nature of the public protector's remedial action, the fact that she was instructing now amendments to the Constitution, and it had an impact on the economy as a whole, and there were questions about the legality and validity of the remedial action. So now everything blew up at once after the release of the report.
And what then happened? You then say you recall speaking to Mr. Kekana. Tell us what transpired.
Yes, I don't know whether he called me or I called him, but then the issue of my research came up, since it's now relevant to the remedial action that we contemplated, because the remedial action basically then circumvented what we were trying to endeavor with the submission to the Constitutional Review Committee. So, but I ended up sending him a copy of the research document and said it was still a work in progress. As I said, I'm not sure if it was for him to address the aftermath of the CIX or whether it was just informative and information that could support or anything that they were thinking or it would have been of any value to him, but I sent to him a copy of the draft document saying that it was still a work in progress.
So then if you go down, you say there, this was so as I was seeking to support the instruction given to me in preparing the submission. And you say at that point, I had not yet given thought to whether it was feasible or put in any countervailing views. The document lacked the conclusion and recommendation.
Yes, it was incomplete. We haven't come up with any substantive recommendation to say this is how we think, because the motivation was to substantiate a review. And say these are to sort of guide the review as opposed to coming up with concrete wording of how we think the constitution should be, well, knowing as well what the impact could be of any words that we put out there. So I was still not at that point, because that required careful consideration, and we didn't find enough support yet.
You see at NVM 5 at page 4118.
Yes. Yeah, and that's when I sent Mr. Kekana a copy of the document.
Right. And you make it clear to him it's an incomplete draft document that you're working on.
Yes.
Right.
That is on the 20th of June.
And that's after the CX report was issued.
Yes.
Right. Now, I asked you whether you had provided this document to anybody else prior thereto.
No, this was the first time that I dispatched the document to anybody.
And I asked you to go and double check and triple check whether you had provided it to anybody else. And did you do that?
Yes, I checked in my normal email on all Outlook items, as well as on Mindcast. I did research on all the searches on all the various keywords, central bank, the Bogo. I checked all my emails to him around the time. I checked all emails under the subject heading, and I couldn't trace any other communications to any other person on this matter with this document.
Now then, if you look at NVM 6, go to NVM 6.1 first. You then asked to assist with a media query in relation to the CX report, correct?
Yes, that's correct.
All right. And the PP then instructs that you must assist in the crafting of this media query.
Yes.
And Mr. Kekana comes to you and he asks for your assistance.
Yes.
And if we go up at 4119, you then ask him to provide you with a copy of the report as finalized.
Yes.
Right? Because you'd not seen the final version.
No,
and
no, I only heard about it in the media. I haven't seen it at the time. Sorry.
And then in September of 2018, if you look at Annex to NVM 6.2, right, you provide a copy of your research and the draft you're working on, as well as the notes of the research to Mr. Nemasisi. How did that come about?
Yes, that was for the purpose of the litigation, the review of the CIX report. This was to prepare, to help the legal team to prepare for the various grounds on which the report can be defended after the fact. And so Mr. Nemasisi asked me, and I provided him with a copy of this research document.
And in your view, whatever was contained in the CX report, could it have been informed by the research that you had done?
No, because it was not shared with anybody that was involved with the CIX report. It was not done before the CIX report. And frankly, the approach was totally different. If you look at the eventual remedial action in the CIX report, it contained specific instructions or directives for the amendment of the Constitution. And we were still contemplating in this document to propose a review and how to motivate a review of the Constitution. So it's totally not aligned to what we had in mind. And as I said, it was not shared with anybody prior to the finalization of the CIX report.
Did you ever complete that submission to the Constitutional Review Committee?
No, because it became water under the bridge, because we've already basically made issued a directive now. So we can't go back and now propose a review if we've already taken remedial action that sought to compel the amendment of the Constitution, and then to go back to a lesser intrusive approach of suggesting a review. So it wouldn't have served any purpose to complete it.
In paragraph 31 of your affidavit, you say you were never consulted in respect of the proposal that was contained in the CX report. Is that correct?
Yes, that's correct. I did make mention of the fact that we were asked to deal with as a mini think tank with the report, but that version of the report didn't have any remedial action that included a constitutional review, to the extent that it eventually was in the CIX report.
And you also say you don't know where the proposal came from. That was contained in the report.
Yes. Yeah, no, the wording like it was in the final report. I don't know what the source of that is.
In paragraph 33 of your affidavit, you indicated that you were contacted by Advocate Mkhubane on the 18th of July this year.
Yes, when Mr. Kekana was testifying, they counsel produced this paper, and he made certain propositions to Mr. Kekana, suggesting that PP, this was one of the documents that might have influenced the proposal, and the PP later on contacted me telephonically, mobile, and asked me to provide a copy of the email that I sent to Mr. Kekana. And I had a problem that night with load shedding, but I sent it to her early the following morning about 6:30 on 22 July, clearly showing when I had submitted it to Mr. Tebogo.
Right. Now, you then in paragraph 34, and I want to run through this quite quickly. You had some involvement in the CX investigation and compilation of the report, correct?
Yes, that's correct. I first went to the investigators, with the investigators, to the ABSA offices. I was not one of the investigators, but they had to go and access certain files. ABSA didn't want to give it to us or copies. We had to go and inspect them there, and they anticipated that some of the records were in Afrikaans. So I was going along to interpret and also to translate some of these documents. And then in February 2017, there was an inquiry from one of the organizations that we mentioned early, Black First, Land First, had written to the PP about this issue. And one of the concerns they had raised was around the tax implications. And I was asked to provide some information to research the tax implications of the so-called lifeboat transaction, the gift to Bangkok. And also...
sorry, stop there quickly for Mr. Van Rijn. Can I just take you to the page, annexure 8, page 4125 of your affidavit? It is the letter which came in from Back First, Land First.
Yes.
Correct? And I just want to draw you to the first paragraph. Black First, Land First, and we see the abbreviation there is BLF.
Yes.
And that's the letter to which you referred to earlier in your evidence, where you said you knew that BLF was the abbreviation of Black First, Land First.
Yes.
Right. Okay. Sorry, I interrupted you. We can go back to 34 3 and 4, you couldn't find a submission that you had made on the taxing matter. And then you pick it up at 34.4, where you say that you were asked to take part in a mini think tank with Advocate Matlawi and Advocate Fourie.
Yes, the committee might know that the think tank process was a peer review process where the managers and knowledge management and research and legal would sit around and look at reports. But there was a resolution of the task team in March that there would be just a mini think tank on this report. Myself, Advocate Matlawi, and Advocate Fourie was the executive manager at the time, would go through the report. Mr. Matlawi told the PPI I had an injury and I was not at the office, and Advocate Fourie was also not available. So the PP indicated that the think tank should go ahead and only with Mr. Kekana and Mr. Matlawi. But I had an executive summary of the report. And in order to try and make a contribution, I did go through the executive summary, and I did make quite a few inputs to the issues that that I felt were relevant, what we would have done in the mini think tank.
And the gist is, at the time when you got the draft at paragraph 34.7, you say there was no reference to amendments to the Constitution in the draft.
No.
Right. And you say that after providing your inputs, you were not further involved in the finalization of the SEX report, correct?
Yeah, no. After making those inputs, and it was quite substantive, we didn't know if it was ever taken into consideration or anything. That's the last I was asked to be involved in, the CIX report, the CIX report.
You then subsequently attended. Okay, go, Mr. Van der Merwe. You subsequently attended the consultation with counsel in August, yes. Correct?
That's correct, yes. Yeah, there were two issues, basically my research background, and then one of the issues that Mr. Nemasisi identified was the fact that APSA raised the issue of prescription. The fact that this transaction had taken place such a long time ago. And I prepared an opinion on prescription relevant to the public protector on the issue whether or not it would limit the public protector's remedial action. And my conclusion was that no, it did not, it could not serve as a limitation. And he wanted me to present that opinion to counsel to see to what extent it could assist in either the responding affidavit or the litigation in itself. And I did make notes of the meeting, and I did share it now, and it's included in my affidavit.
Right, but you point out that that was prescription in an entirely different context, correct?
Yes, that's correct. Yeah.
You were also then asked to do an affidavit for the PP to clarify your recommendations in relation to the CX report.
Yes, I can't remember whether it was for the purpose of this motion or the criminal matter, but I was asked to put my involvement in the research, basically to support through the research. But I then, when Mr. Sitole reminded me, I did send him an email. I just couldn't trace it, that I wasn't sure that my recollection and the documents that I had would be helpful. And I didn't hear anything further. I wasn't requested to finalize such an affidavit.
Right. We then come to that part of your affidavit that heading complaints. Now, you were at some point requested to prepare statistics regarding the handling of complaints by the communication department for providing an overview of the office over 20 years. I'm going to, it's a next year affidavit as annexed to NMV 12. I'm going to put up on the screen a revision of NVM 12, which deals with the 25 cases, reflecting updated figures. Okay.
Sorry, Chair, can I just, on the last issue, just point out something? Whether or not the affidavit that I was requested to provide would effectively be the same, take the same factual circumstances that I've provided to this committee.
Now, so Mr. Van der Merwe, if we go to the revision, the revised NM 12 documents on the screen, right?
Yes.
The difference with this is that we put in totals for all the public protectors for the periods in question. Right?
Yes.
We're going to come in a moment to an explanation of what is received, finalized, and carried over. But
Yes.
Could you just explain the document, and then we'll scroll down and we'll look at it? How
Yes,
it's set up.
now every public protector is appointed for a period of 7 years, but remembering that their term would start in October, so it doesn't correlate with a financial year or a calendar year. So it's difficult. We took the statistics as it was reported at the end of every financial year as per the annual reports. And this was an exercise I did previously before for the 25 years celebration, and then I just elaborated on that. It takes the period of every public protector, and then the cases that were received during his or her term, the number of cases that were finalized in that year, were carried over the budget of the office during for that financial year, and then the staff complement in the public protector's office. So it dealt with Advocate Backlog, the first public protector, then from 2002 to 2009, October, Advocate Mshwana, and then
So for the record, can we just put the totals in as received, finalized, and carried over? So in
yes.
the Advocate Backlog period, if you can just take us through the totals of each public protector.
Yes. Yeah, we've in Advocate Backlog's time, we received 44,627 cases. We finalized 36,669 cases. During that whole period, and that doesn't mean that at the end of the period, it was the number of cases carried over. It's just cumulative, because we only carried over the number of cases. So it would also reflect during the course of the period how many cases were carried over, but it was not at the end of the period. So the same for Advocate Mshwana. We received during his term of office. And this is relative because of the fact that the reporting periods would not correlate with their terms of office. In Advocate Backlog's time, we carried over 13,000 cases. Then when at the start of Mr. Advocate Mshwana's time, we received 15,000 cases. That's why with the cases carried over, we were able to finalize 20,000 cases during this period. And we totally, in Advocate Mshwana's time, we received 113,984 cases. We finalized 110,632. That number carried over would be throughout the period. Effectively, at the end of his term, we carried over 5,900 cases to Advocate Mshwana's time.
Yes, and Advocate Van, you reflect in the last two columns the budgets available to that public protector and the number of staff members as well, correct?
Yes, that's correct. Yes, 92 million at the end of Advocate Mushwana's time and 240 something staff members. Sorry, this window is 247 staff members. And that would include investigators and support staff.
Right. And then we come to Advocate Madunsala's period.
Yes. For the whole period, we received 136,841 cases, and we finalized 131,050 cases. At the end of her term, we broke up between the actual amounts. We basically split it in half because it was 6 months, 6 months. She took, Advocate Kwebane took over 6 months into the financial year. So we just took the whole of the number for 2016-17 and divided it by 2. So Advocate Madunsela, for that 6 months, we finalized 5,394 cases, carried over to October 2016, 5,255 cases. And then we would now come to the current partial period of Advocate Kwebane.
Right. So let's go down and bear in mind that we're not comparing apples with apples because we're effectively 1 financial year short in the period for Advocate Kwebane. That would be correct, right?
Yeah, this is March 2022 this year. So we still left with 18 months. At that point, there was still 18 months of the term left for the to complete Advocate Kwebane's term. But so thus far in the term, we've received 42,302 cases, and we finalized 54,334 cases. And at the end of March this year, we carried over 1,937 cases. You would see that it reduced drastically through the last number of years.
Right. So there has, as we've heard from other witnesses, a significant dent made in the backlog of cases.
Yes, well, this backlog is particularly the older cases that we were exceeding 2 years or that we carried over to the next financial years.
Right. And then we specifically deal with, if I take you to paragraph 38 of your affidavit, right? You deal with annual statistics as it appears in the annual report on the PPS's caseload. And you say you confirmed the information that you're dealing with now with the senior manager strategic support. Can you explain that to us? What's her role?
Yes, she collates all the statistical data. She monitors performance against the strategic plan, targets, and APP. And all the statistical reports, management reports, would come to her on a monthly basis and a quarterly basis against the APP. So she's monitoring the strategic performance of the office and reporting on that to the various management structures within the office.
Right. And you then set out to explain how the statistics in the annual report work from paragraph 39, and one has to look at that with reference to NMB 13. So Mr. Van der Merwe, I'm going to let you go through your affidavit and put NMB 13 on the screen. Would that work? You've got your affidavit?
Yes, yes, I have it.
Right. Right. So NMB 13 is the caseload and statistics for the 2020-2021 period, correct?
That's correct, yes.
Right. And so we look at that, and I lead you in this so that we could do that. You essentially have 10 categories: head office, and then the 9 provinces, correct?
Yes, that's correct.
And the head office collectively reflected the CSM, which is what?
customer service, and stakeholder management.
Right,
And
administrative
then-
justice.
Yes.
Okay, go ahead,
Previously,
Mr.
there was a
Panel.
unit. Previously, the investigating units in head office were divided between service delivery matters that were dealt with by what we called AJSD, that's Administrative Justice and Service Delivery Unit, and then GGI matters. That came long ago from the special investigations. They dealt with good governance and integrity matters, ethical matters, corruption, procurement, and so on. But nowadays, it's just one investigative branch with more than one. We've now have PII, which is provincial integration, head office investigations, and customer service and stakeholder management at head office.
Right. So the moment a complaint comes into the public protector's office, it gets a complaints number, correct?
That's correct, yes.
And this is an accounting of everything that has a complaints number, irrespective of whether it's been investigated or not.
Yes, that's correct.
Right. And so you have a category on the top, which you see, which says finalized cases in, and that's the finalized cases for the financial year,
Yes,
correct? And that would include cases that had been withdrawn by complainants, cases where the complaints have been resolved prior to investigations commencing, cases that are referred to other institutions. For example, we were told that there are agreements with Home Affairs, for example, where complaints don't get investigated, they simply get referred, and cases which are rejected because the public protector has no jurisdiction.
yes,
Correct?
that's correct.
Right? And we know that in the annual report, these are recorded as closed without investigations and are distinguished from complaints that are either substantiated or not substantiated.
That's correct.
Right? And we see that on page 4180A of annexure in the next page. If you just go to the next page, we see that extract from the public protector's report. And we see there that out of the total complaints, the annual report will tell us that 41% was substantiated, 23% was not, and 16 had been closed without investigations. Correct?
Yes, that's correct.
So now if we go back up to the 2013, the 2021 to 2020 financial year, we will see that there is a total that comes in that is reflected on the documentation as being the number that for one financial year, correct?
That's correct, yes.
Right, so now if I, sorry, if we go to the so the starting point in each year, if we go to NMV 14, NVM 14, which is at page 4181. Okay, maybe if you could just bring it further down so we can see the 2021 year. Right. We'll use that as the example, right? We see there that there's a backlog that comes from the previous year of 3363, correct?
Yes,
Right, and that's carried over at the start of the financial year. You
yes,
then get 5,108 new cases that comes in.
yes,
And so you start off your year with 8,471.
That's basically throughout the year. That's the total cases handled.
Throughout the year, not just at the starting
Yes.
period. You're right, correct.
Yes.
For that financial period, cases that is marked finalized is 6,927,
Yes.
right? That would include the 23%, which we have seen is closed as not being substantiated, correct?
Yes.
Right?
Or referred or declined.
Or decline. If you look at the heading, if you just go a little bit up on the document, you will see the heading says that that percentage is the no jurisdiction referred to other institutions, withdrawn by complainants, resolved by parties before the office could conclude the investigation.
That's correct.
So we've subtracted from the total the number of cases that does not engage investigative resources. Would that be
Yes.
correct?
Yes.
So in other words, the total that one sees under the total investigations finalized reflects a total of 5,334 cases, 5,334 cases that actually engage investigative services. And I say investigative services because that would include your CSM officials who would register it and then pass it on. Would that be correct?
That's correct, yes.
And so effectively for the period, although the finalized total would reflect over 50,000 cases, for the period in question, the total actually investigated is 40,117, correct?
That's correct, yes.
Right. And Mr. van der Merwe, this is a statistical issue. This is not, I don't want us to be misinterpreted here. The other public protector report, as far as you're aware, reported it on the same basis of finalized cases. Am I correct?
Yes, so this wouldn't mean that this is 40,000 as opposed to 156 or 110, because the same exercise was not conducted in respect of those statistics. It's just high level compared to a deeper drill down of these specific statistics.
So if you were doing a comparison, you would use the figures that you had relayed over the 25-year period. But if you wish to show what was actually investigated by the office, then this would be the figure you would use, correct?
Yes, that's correct.
And then you would carry that over to the next financial year of the 1197, right? And in the
Yes.
last two financial years, you would show what is early resolution, what is service delivery, and what is GGI,
Yes.
right? And can you just briefly tell us what's the difference between the three?
Early resolution is investigation without embarking on an evidence gathering exercise. The aim of early resolution is to resolve the matter. Usually in an investigation, the point is to gather evidence to make an adjudication on the merits of the matter. And early resolution, the methodology as well as the outcome is different. We try and resolve the matter without an adjudication. We try and bring the parties together, or try and sometimes by just alerting the institution to a delay, they address the undue delay. And we don't need to make a finding that there is an undue delay. They would either expedite or prioritize the issue of a person's ID or a social grant or whatever was the subject of the complaint. And service delivery in GGI matters involve both investigations as well as what we call ADR, that's alternative dispute resolution mechanisms, where we bring the parties together to try and resolve the matter. But the primary course of action is to investigate, gather evidence, and then to close the investigation by means of the various options available to the public protector.
Right, and then
Thank you. Let's pause there. We'll take a tea break and come back at 15:45.
Recording
15 minutes.
stopped.
I'm on page 21 of his affidavit.
Francois van der Merwe, as jy daar.
Ek is hier so, dankie, voorsitter. Thank you, Chair.
Dan gaan ons aan. Advocate Bauer, we resume.
Before the adjournment, you were explaining to us early resolution and service delivery matters. And essentially, as I understood it, early resolution matters are matters which get resolved quickly. Service delivery matters is usually government departments or organs of state that is meant to render service and don't, and there's a complaint to the Public Protector's Office, essentially. And then the more complicated and the complex matters is the GGI matters. If we put NVM 14 back up on the screen. And these statistics, Mr. Van Merwe, in the annual reports only appear to be detailed in this manner in the last 2 financial years for early resolution, service delivery, and GGI, right?
Yeah, the breakdown is only over the last 2 years.
So
previously it was just general.
Right. So one sees in the breakup of the complaints in the numbers that are there in the columns which show you what the bulk of it is made up of, right?
That's correct.
And then the HA column is Home Affairs. That's the amount of complaints that goes to Home Affairs, correct?
Referrals, yes. What I can also add, if you allow me, is, and it's not only about the nature of the complaint, early resolution in terms of the service standards of the public protector. There's a predetermined period of time allocated to the finalization of each of these categories of complaints. And the backlog would then arise once it exceeds the prescribed service standard or prescribed time frame.
Okay. So if you look at the outreach clinic, which is the second last column, and we had Ms. Mutsetsi testifying to this, so we're not going to take you through it. There has been a decrease in outreach clinics for reasons which she explained to the committee already. And then we look at the last column, which is reports. There has been an increase in the last 3 years, in particular in the number of reports that get issued. If we go much higher than in fact has been issued by any other public protector, would that be correct?
That's correct, yes.
Right. Now, if we take you to 39.16 of your affidavit on page 481, you, with reference to 39.16, right? The preceding subparagraphs is essentially the explanation that we had now afforded as to how the table operates. And so there are 3 types of reports or categories that the reports fall under. Could you just briefly tell us what each are?
Is closing reports. Those are reports that are issued without where the investigation reveals that the allegations are unsubstantiated or the matters were resolved before the issuing of the report. So it would not mean an adverse finding against the institution. That are signed off at 2 levels. One is an executive management level and senior management level, and then there are closing reports that are signed off by the public protector. It would be, for instance, on Executive Members Ethics Act, and that would be included in the statistics. And then formal reports with findings and remedial action in terms of Section 182 of the Constitution. That is usually when the allegations are substantiated, and the report would cover both findings and remedial action. And then there would be advisory report, which is in terms of Section 64C2 of the Public Protector Act. After an investigation, when there's a systemic issue or a root cause issue, and the public protector does not have enough evidence, or is not substantiated by means of a completed investigation, but we were still able to identify a problem. That's to benefit people that might not have come to us with the same problem. And we want to improve in a proactive manner the administration. Then we advise the institution of what the Constitutional Court referred to as remedial measures, as opposed to remedial action. It's the classic recommendations that ombudsman officers or public protectors officers would do. And those are the 3 types of reports covered in the statistics.
Right. Now, you also point out that that doesn't include reports that are finalized and signed off at provincial level. That's not reported in the annual report. These are only the reports that are signed by the public protector herself, correct?
That's correct, yes. Because
And most
all
of the
those statistics that you reflected of matters finalized, they would all require a type of closing report, and that would be done on unit and branch level.
Right. Then you say that most of these reports relate to GGI matters, and it's mostly those formal reports that get taken on.
Yes. Yeah, because the findings as well as the remedial action relate to conduct issues, where there's service delivery and there's a delay, it would mostly not be in dispute, and we would be contributing to an improvement of the service delivery. But most of the reports that are taken on review are those that deals with conduct, findings on conduct of either politicians or heads of departments or chief executive officers and so on. Am I still audible, Chair? There's a silence, and I'm not sure if it's on my part.
I seem to have lost M46. We can't hear them.
Oh.
Yeah, I want to limit we've just lost 46. I'm not sure if I can hear it like they are back.
I'm muted here. Okay, sorry, colleagues, we were muted, which is not a usual thing. It's a very strange thing. We normally mute you, but we're muted somewhere. So that's a different experience. Mr. Van Merwe, are you there?
I'm here, Chair.
Thank you, Advocate Bauer. Please continue.
I put the proposition to you that the increase in reports that have been issued by the public protector has been as a consequence of an endeavor to deal with these outstanding GGI complaints. Would that be correct?
Yes, definitely. The backlog issues that, because part of the reason why the backlog was incurred, because it's more complex matters. So that will naturally take time, and there was an endeavor to finalize those matters. So you are quite correct, Chair.
And so you deal from paragraph 40 of your affidavit on 4082 with the issue of backlogs quite briefly. And you point out that the previous, the 2015-2016 report, the overwhelming majority of cases finalized did not result in formal investigations. That's the year preceding Advocate Mkhubane, correct?
That's correct, yes, Chair.
And they used ADR mechanisms, mediation, conciliation, etc. And this was also the case in the 2016-2017 period.
Yes,
Right? And the backlog had been a long-running difficulty, with some cases running beyond 4 or 5 years.
yes, 46 months, 42 months, like that, yes.
And so Advocate Mkhubane implemented a different approach, a new model being done top-down to eliminate and reduce this backlog and the time periods involved, including weekly task team meetings, extracting commitments for deadlines by when investigations must be completed.
Yes,
Correct?
that's correct.
And then you said the CEO was appointed to manage and reduce the backlog, and she was Ms. Paloi was quite effective in doing precisely that,
Yes,
right? And that she developed a good relations with the team, put systems into place to speed up the investigations and managing the quality control. Correct?
that's correct, yes.
You then refer to 2 extracts in the 2016-2017 report, as well as in the 2018-20, actually 3. Can you just take us through these 3 extracts?
Yes. In 2016-17, the backlog matters were reduced by 77%. In line with the investigation plans. The difference in approach is that bottom up is there's an investigation plan, and it depends on the investigator when or not it is escalated or intervention is required from the executive authority. The top-down approach is that the public protector intervenes and sets deadlines for the outstanding matters. And in the next financial year, 61% of the cases out of 417 out of 682 cases that were older than 2 years were finalized by the end of that period. The reason was the complexity of some of the cases that needed to be resolved. The lack of responses, that was for the matters that could not be resolved. And then there was a 67% reduction in cases older than a year in 1 April 2016. This was due to investigation teams dedicating more time to actually focusing on the backlog. We recorded, and in the annual report, the reason for the backlog was recorded as the absence of an electronic case management system, delays by the organs of state to respond to the inquiry letters and providing of evidence, or availing themselves to meetings. That was the main reason for the backlog. And then in the 2018-19 report, the turnaround time of 6 months for early resolution was adopted. That's when we started with it was actually the year before with the service standards. Service delivery matters were given 12 months and GGI within 24 months. And of the cases finalized, 99% were completed within these turnaround times. And 77% of the backlog cases that were 2 years and older were finalized. And then in the 2019-20 report, the public protector again exceeded the target of finalizing at least 7,000 matters on our caseload by nearly 5,000. So 12,000 cases were finalized. The achievement of this had a positive effect. The objective was to finalize 56 reports, and it was nearly doubled, or more than doubled. In 157 reports were finalized, 81 reports more than was targeted, and 95% of the caseload were finalized within the set turnaround times of 6 months, 12 months, and 24 months. And to achieve this, it meant a lot of hard work.
So essentially, there had been significant progress done on the backlogs over a number of period of years, correct?
That's correct, yes.
Right. So then, and you say this was achieved with the investigators, senior staff working extensive hours.
Yes. Yes, because I know a lot of has been said about the performance culture of the office, which is obviously also improved, but this is not without a lot of stress and sacrifice amongst the investigative staff, because these deadlines were, the delays were there for a reason that was well recorded. And none of the circumstances changed. We didn't have a case management system. We didn't have suddenly an increase in cooperation from government departments. So it was mainly because of internal efforts and the dedication and the hard work from investigators that resulted in the, under the direction and under the structures that were put in place, that these improvements were achieved.
Right. Now, if we then turn to the review applications that have occurred and the legal fees, you heard the evidence and you've been party to compiling the schedule, which was largely referred to during Mr. Satoli's evidence, correct?
That's correct.
And if we go to NVM 15, we will see from this summary of the total revenue, which is all the money at the office's disposal for the relevant periods, that by far the bulk of the money for the office go down is spent on its human resources.
Yes, COE, we call it cost of employment, COE, that's for the warm bodies of the office.
And you effectively left with just over 100 million in the last 2 financial years. In fact,
For operational costs.
Yeah, where you operational costs, which means funding the offices that exist across the country, investigations, outreach, administration costs like stationery, telephone expenses, and
leases.
That's right.
Yeah,
right.
That's correct.
And if you then go to paragraph 48 of your affidavit, you make the point that as litigation costs increase, it obviously meant that other costs had to be curbed.
Yes, because COE cannot be sacrificed. That's a set, as long as the positions are filled, the cost there is fixed. So the only variable is in terms of operational costs.
Right. And so you make the point that it has a knock-on effect on investigations when the resources become more limited, correct?
That's correct, yes, because in the MTF and Treasury, there are funding requirements in terms of additional funds where relate to the additional resources, not COE, not the permanent establishment, but expert evidence and expert witnesses and training and those kind of things that comes from the variable part of the budget.
Right. Then you deal with the issue that as more reports get issued, it obviously meant that there's more focus on it and it means there are more reviews. Correct?
Yes, because the we found that there's general, what we call a litigious response or culture from government departments. Because in Nkandla judgment said that if a matter is not taken on review, the remedial action is binding and it must be enforced. So we found that as a default position, many of the institutions would revert to, we raised this as a concern with access to justice with the Law Reform Commission when they reviewed legal fees as well. But it became a big problem, the escalating number of reviews.
Right. But obviously the cost on cases differ from case to case. In fact, the approach adopted on cases and the persistence of cases would impact on how much is spent on cases as well. Would you agree, Mr. Van? Right.
Definitely, yes.
You also point out in paragraph 50 how that gives rise to review applications, and in paragraph 51 you acknowledge that mistakes do happen and errors do occur that cannot be rectified and would result in matters having gone to court. The question is whether you persist in defending the report, or you acknowledge the error and you accept that the report must be set aside.
That's correct, yes.
You also point out that unless the report is remitted, the investigation is not revisited.
Yes, yeah. Very few, if any, of the reports that were set aside would be re-investigated and issued. That means effectively that the beneficiary is left without a recourse or redress for his matter, meaning the public, the people that are in the intended beneficiaries of our services.
But you also then go further and you say that a number of these reports do not go through the prescribed assessment process, or there's not sufficient time before it's issued for it to reach those structures, for it to be properly quality assured.
Yes, the two main problems is some of the reports, the challenge or the gap with the report would start with the very early in when the complaint was lodged and accepted. There are certain requirements there in terms of how it must be assessed, the timelines within which it must be accepted, and some of those reports were accepted without compliance with those timelines. And then later on in the investigation, you get two types of gaps. The one is that we might, or in the view of the court, might miss certain processes, not complying with principles of the that's in the perception of the courts, the requirements for a good investigation, open and inquiring mind, or then procedural matters where we didn't notify parties of the adverse findings and later on the remedial action. And those are the main areas that then are highlighted by the courts as areas that result in the setting aside of the reports.
Right. And so you say that there are times that these reports have actually not reached the quality assurance mechanisms put in place.
Yes, some of the reports would not come through because there is we're working currently on a reviewed standard operating procedure, but in terms of the general SOP, there was a process after COO. The reports would go through the structures. First, the mini think tank at the unit branch level, then the COO's office quality assurance, and these days what we call the full bench. And these are all peer review mechanisms going through the report, and then it would be submitted to the public protector for signature. Many of these reports, some of the more, I can't say, but some of the more public interest matters sometimes would not have gone through this peer review process. we wouldn't have seen it as the internal structures of the office. They would have been signed off by the public protector directly between the branch and the public protector without going through the peer review and quality assurance mechanisms.
Right. And do you sit on those quality assurance structures?
Yes, quality assurance and full bench.
Right. And before the existence of full bench, were you also part of quality assurance then?
Yes, we would not quality assurance. We were knowledge management at the time was part of quality assurance. And then we would have also been asked to check on an ad hoc basis if there are any specific legal research questions that would pop up. But generally on up to the level of quality assurance, yes.
And then in paragraph 54, you say that the litigation has been the domain of legal services and they act on instructions from the PP directly.
That's correct, yes.
Right. And continue. Sorry, Mr.
No,
Van der Merwe.
there's a litigation strategy that sets out the process, how we would obtain a principal decision, whether or not to oppose or to abide, or to what the specific response to the litigation would be. And then there's a process for the appointment of service providers as well.
Right. You then point out that there was litigation reports would go to Manco on which you sat, and during the time of Mr. Nemasisi, you would write a memo to the PP, who would then, what would happen in the matter? A decision would then emerge, and an external legal representative is appointed, if any. And that, as far as you recall, Mr. Mshlongo adopted the same approach. Correct? Have we frozen again?
Mr. Van der Merwe? Hij is uitgeskopt. Can you hear us, Honorable Heron?
Yes, Chair.
So the problem, thank you, must be with Mr. Van der Merwe. Let's just take a few minutes and fix that.
Recording stopped.
Are you late?
Hi, Chair. Mr. Van der Merwe disconnected again. He will try to reconnect. He's asking for a minute or two. Thanks.
No problem. Thank you.
Recording in progress.
Thank you, Mr. Ngoma. Mr. Van der Merwe, are you back?
Yes, sorry, thank you, Chair. Sorry again for the interruption.
Okay, you just got frozen there. Are you fine now? Mr. Van der Merwe? You just came in, I think you've just
Sorry,
frozen
Chair,
again. Yes.
Yeah, it shows my internet connection is unstable.
Okay.
The office, I will.
Maybe for just
if it continues, I'll go to a third device.
That's fine. Or maybe you can just switch off your camera for that process and see, we see how it works.
Okay. Thank you, Chair.
We're just trying to preserve it. I don't think you would change after this and get another Mr. Van der Merwe. Advocate Bauer?
Mr. Van der Merwe, I pointed out to you in paragraph 55 of your affidavit, the process that was adopted in obtaining the approval from the public protector via memorandum. And you pointed out that Mr. Nemasisi's successor, Mr. Mshlongo, adopted the same approach, and that memos would be sent to the CEO to appoint a firm of attorneys to represent the PP and sign off on the payment of fees. And you then provide an example of how that was done as NVM 16, correct?
That's
We
correct,
can't hear
yes.
you. Yeah, okay, we've got you.
That's correct, yes.
Right. So you then in paragraph 56 point out that the GNR approach was adopted. Could you just tell us what that was? Mr. Van der Merwe, we can't hear you, so we're not sure if you're frozen or if you can hear us.
Yes, let me try and switch to another. Okay, perhaps it might be better. Can you hear me now, Chair?
Yes, we can hear you.
Yeah, the connection seems to be quite bad on our side. It's through the office network, but I'm not sure what's disturbing it. Otherwise, I can just try and revert back to the mobile connection.
Okay, we can hear you. We can hear you now. Let's see. Let Advocate Bauer speak to you.
I asked you to just explain the GNR approach. Which is referred to in paragraph 56 of your affidavit.
Yes, the GNR is when legal services signs off that the service has been rendered and the invoice should be paid. We get invoice in accordance with our tariff of fees. And then the legal services would check the invoice against the appointment letter and the work done. And then they would process it through to SCM and finance, and they would process the payment on the GR on our electronic system, which is the GNR system.
So you then say that it's not clear whether the CEO's attention is drawn specifically to the cost of litigation. Can you explain that?
No, because she's not a, yeah, she's not, she is not a approver in this GNR process. It happens between legal services, supply chain and finance. And the CEO would basically only know about the litigation impact and if the legal expenditure report is presented on a quarterly basis at EXCO or MANCO. But in terms of the process, as I found it, it's not, it doesn't need the approval of the accounting officer.
And you also say,
payment to be.
and the cost of each case is not reported, has not been reported individually at MANCO meetings.
No.
So you confirmed with the CEO that once the litigation decision is taken by the PP, the CEO is neither apprised of nor signs off on the legal fees incurred.
That's correct, yes.
So the end user who signs off on it is legal services.
That's correct.
And you then in 57 say Under Mr. Satauli, there were matters that were dealt with by an external legal service, and there was matters that was dealt with internally, both unopposed and opposed. Correct?
That's correct, yes.
Right. And the internal opposition was part of the strategy to curtail costs.
Yes, we expanded legal services by the appointment of legal advisors with the intention to oppose matters internally without having to appoint external legal service providers.
Right. And Mr. Satauli then also appeared personally in court under the misconception that he had rights of appearance as a legal advisor. Correct?
Yes. Yeah, yes, we were not aware of at the time that we could not practice. We were not allowed to operate as a legal practitioners appearing in court on behalf of the public protector.
And the legal cost that was incurred was meant to be confirmed against the tariffs and the written appointment letter by the attorneys. Correct?
That's correct, yes.
And since you've taken over senior manager legal services, have you found that this had been done in all instances?
No, we had a number of concerns with a number of firms. Some of them from the onset, some of the invoices that you displayed earlier show that even after we distributed the tariff of fees, the attorneys would still, for instance, charge on an hourly rate instead of, or a day fee instead of per item on the tariff of fees. And it is a few, not the exceptions, basically. The majority of the legal invoices and statements of account are rendered in accordance with tariffs, but there are also have been some of the matters that have not been, and it was acknowledged before the committee.
Okay. And there's been cases where you say in paragraph 59 deals with the table of the summary of judgments and cases we've already dealt with before. And you then point out there've been cases in your view that the PPSA could have opposed more vigorously because the litigation and judgment served to curtail essential powers and the discretion of the public protector. But there are certain reports that were so weak that they would inevitably be reviewed and set aside, and no purpose is served in putting up that any kind of defense. Correct?
Yes, that's correct. It doesn't matter how much we would argue the gaps and the flaws were incorrectable, and the courts were going to find in any event that it would not withstand scrutiny.
Right. And you then in paragraph 61 point out that you're not part of the litigation strategy adopted in cases, and you can't talk about why some cases were vigorously opposed from High Court right up to the Constitutional Court, while others are not during the same time period when the same financial constraints and resources would have existed.
Yes. Even in my experience as an investigator, some of my own reports when I was an investigator would be taken on review. Some of them would not be opposed, and then others like the Vembe matter and the NEF matter. The Vembe matter referred to quite a number of citizens, quite a big group of people, and the report was set aside, but then that was the end of it. We, at the time of the NEF matter, dealt with a imported principle of what we call sorry money compensation or redress, and we couldn't take the matter any further because the report was not strong enough but that was also the end of the matter, while other matters appeared to be pursued to the highest courts.
Right. And so you point out that certain reports that should have been defended was not defended because of lack of funds.
Yes, if you look at our litigation report, very few, actually now even less, at one point we had about 60 something litigation matters. And I think if we were in a position to oppose 20 or more of them, it was a lot of the matters we had to abide or withdraw opposition or just abide by the outcome or file an explanatory affidavit. With the litigation costs contributing a lot to those decisions. Just looking at it from ex post facto point of view, I was not part of the initial processes, but I can just see the number of reports that were not opposed.
Right. And so at paragraph 64, you say there'd been a significant increase in the litigation, as well as on the question of legal opinions that's being obtained. And we'll come to that in a moment. Not all of it relates to the review of reports, correct?
Yes, yes. The litigation budget started from, I don't know when, I think it was less than 10 million up to about 25 million at one point, and now it's going down again. But yes, it's quite a significant portion of the operational costs. One of the largest cost drivers in the office.
Right. So you point out that the number of cases have increased since the Nkandla judgment, but there's also an increase in the number of reports that won't withstand legal scrutiny.
Yes, proportionally, because we've increased the output on the number of reports were so big, and inevitably there would be matters that, because of the gaps that I alluded to earlier in either the inception stage or the investigation stage or the report writing stage, we would not actually be in a position to defend them.
Right. So then we, in your last sentence in paragraph 65, you say, as far as you can ascertain, it doesn't appear that any report that was not defended has withstood legal scrutiny. Do I understand that if the public protector doesn't oppose in court, invariably it's set aside?
Yes, there's very few. Well, we are still tracking some of the reports that, because they are reporting, our management reports on this didn't have all the information, but we're still tracking those matters that went unopposed and have been set down and have been the subject of a ruling. And we've not been alerted to any of those where the review was not successful and the report was not set aside. The only other matters would be by means of a settlement with the institution, but none of the reports that we did not oppose, I think, that withheld any legal scrutiny, withstand any legal scrutiny.
If we then go to paragraph 66 onwards, we've prepared a number of schedules. We dealt with the reviews in terms of cases. I took the committee through the labor cases and under litigation early on, in a few weeks ago, and the outcome of cost orders endeavored. And we sought to separate those from which Advocate Mkubani dealt with and her predecessors dealt with. The second issue that came up was the question of legal costs. And I'm going to put onto the screen the revision of NM 17. And this arose as I had started to deal with the question of how legal cost was incurred, and the committee then requested a breakdown. Sipo, can you go to the first document Let's see. Yes. Right. Mr. van der Merwe, that is the figures for consulting and professional fees for the respective financial years as reflected in the annual report, correct?
That's correct, yes.
Right. And the first column is the total consulting and professional fees. And the second
Yes.
column is the legal fees.
Yes, that's correct.
So if one looks at it and somehow the percentage has fallen off, it was there, I'll say about fixing it. But in 2016, 2017, something like 6.4 million of the 13 million was spent on legal fees, correct?
That's correct, yes.
At the high watermark of expenses on legal fees, which is in the 2019-2020 period, there was an over expenditure of more than 48 million on legal fees, correct?
That's correct, yes.
So in total, although legal fees for the periods of 2016 to 2022 reflected a total of 150, close to 159 million for professional and consulting fees, approximately 147 million constitutes legal fees.
That's correct.
So would it be fair to say that not professional and other consultants or other professional fees is not a huge component of the amount spent on legal on this category?
Yes, you are correct. They are not a significant portion of the expenditure.
Right. Now, if we go to the next document, actually go to the one that says Senego payments first. Right. Can you identify what this document is?
Yes, it's a document that we drew from our GRN system and from finance of payments on all the invoices that we've processed. And these invoices were specifically then for the firm Senego Incorporated.
Right. And if we go to VZLR payments, we'll see the same for that law firm, correct?
That's correct, yes.
And if we go to Bokwana Burns payments, we'll see the same for that law firm. It comes off your electronic payment system, if I understand you correctly.
That's correct, yes.
And each of the amounts at the end would either reflect one invoice or a combination of invoices that is paid on the given date. Correct?
That's correct, yes.
Right. So now let's go to the document that's called firm fee. Just before we go to that document, let me take you to paragraph 68 of your affidavit so that we can just put it into context as to how it was collated. Right? It reflects the legal cost incurred for the years 2017 to the end of May 2022 and a little bit beyond in some instances, correct?
Yes, yes. Some of them most recently.
Right. And on the figures that we're now going to show, they are done with reference to the actual fee notes that have been paid correlated to the actual invoices.
Yes.
Right. There have been some instances where we've not been able to find disbursement documents, correct?
That's correct, yes.
And in some instances, we have tried in almost all the instances to separate attorney's fees from advocate's fees, but in some instances, we were not able to do that.
That's correct.
Right. And so when we talk about the amount spent on legal fees, it's the attorney page and the counsel brief, except in the instance of Mr. Ngubeni, which will reflect separately, correct?
That's correct.
Right. This, you say, should provide the committee with an indication in broad terms as to what the PPSA was paying for in relation to legal fees, which matters was a priority, and on which limited funds were to be spent. Right?
Yes,
And this exercise was done for the purposes of this hearing and not for audit purposes.
that's correct. Yes,
So it doesn't reflect accrual. So it might be an underestimation in respect of any given financial year when something has accrued.
yes,
And it also wouldn't automatically correspond with your financial statements because it uses a calendar year.
yes, that's correct.
So it's got a different cutoff period, which you would ordinarily do for purposes of that.
Yes,
Correct?
that's correct.
Then, right, so if we go to NM 17 against that background of an understanding, I was asked and I was asked effectively to provide a breakdown of who was getting the bulk or the funds. And what you see is of the 149 million for the period in question, you see the payments made in the broad yellow is the total payments that go to the law firms in question on the principle we've articulated, correct?
Yes,
And so if we take the example, let's just go down to the bottom. We then see that for the period, and we use 2 million as the minimum cutoff for this exercise, correct?
yes, only those firms that were paid more than in excess of 2 million rand.
Can you go up? So it doesn't account for the full 149 million in this exercise.
No,
And we see that 2 of those law firms was only engaged from the 2018 period on the schedule, the top 2,
yes,
right?
yes,
And those firm payments comes to those amounts, right?
yes,
So then we go across the screen, just leave the columns E and F for a moment and just go to G. Right? Can you just make L a bit wider so we can see an amount? The column in line 3 is the total of the amount that goes into what's called attorney's fees. These are all VAT inclusive figures, correct, Mr. Van der Merwe?
that's correct. Yes,
So we see that column being the amount that goes to the attorney. So let's take Sienego, for instance. If you go back to the first column in yellow, of the 55.5 million that we've accounted for, approximately 17 million is the attorney's fee.
attorney's fees. Yes,
Right? And if you go down in that column, you will see now in column G, you will then see what Sienego paid out in the remaining amount to counsel on various matters. And again, we've only taken either the counsel who've earned a significant amount of money or more money, or alternatively where they've been involved in cases which is before this committee in some way or another. So there are many counsel that have been briefed that are not on this list, correct?
that's correct. Yes,
Right. So essentially one then sees these total in those columns, and we can see across the board, if you just go to the end of this, there is the Dyson figure we haven't included because we don't have all the documents to be able to divide it between attorneys and counsel, correct?
yes,
Right. Then you see there's an other category. Right? That's P. And that's amounts which the counsel in those columns have been paid in matters that have not been dealt with by any of these attorneys, but by attorneys who received lesser funds than 2 million, correct?
Yes.
And in the R column, you see the number of matters in which that is dealt with. So for example, in line 6, the council would have received an amount of 1.68 million, but that 1.68 million results to 6 different matters in which he had potentially been briefed or had been briefed. Correct?
Yes, that's correct.
Right. In the last column, we specifically deal with the Vrede matter, right? And that is because the law firm who had been initially briefed in the Vrede matter does not fall into the plus 2 million category. Would that be correct?
Yes,
Right. And the law firms changed from appeal. So this is just the High Court matter, correct?
yes.
So, Shepo, can you just total it? Because I'm not sure if there's a total on that column, or maybe go down and see if there's a total. Or go up, sorry, go up, go up. The total is actually the first column. I'm being silly. The High Court application cost 1.135 million in the
Yes.
High Court, right? That's what the law firm charged, right? So then, if we break it down per case, and the easiest way to do that is let's use one of the law firms as an example. So let's go to the, and I want to take the cases, I'll go to them on the cases that relate to matters before this motion. In particular, go to the CNEGO fees. Right, so let's go to the top. You have the date of the invoice, the name of the matter, the amount of the total fees that is attributed to the attorney, and that includes disbursements. And for CNEGO, we called it other because Mr. Ngubeni is not an advocate, so we didn't put junior. So what he spent on other, and then we have SC, what the SC gets. Just go across so that we get an indication, just a little bit, right? And then we have a separate total, but let's go to the combined totals, right? Just go, now go to the left, go to the left, right? So you will see in H, there's a total of the total amount of fees spent in relation to matters in that regard.
Yes.
Now, in the first category, those were the invoices that we referred the committee to earlier, which relates to the portfolio committee. And at number 4, we make the point of this included the opinion on the court application for the declaratory order. So it wasn't totally a submission to the portfolio committee.
Yes.
Correct?
Yes.
And that came approximately just over 380,000.
Yes, for one submission to the portfolio committee.
Right. Then if you go down, we see the, can you see there's another column to the left, Shepo? Go again to the left. Right, let's go a bit more. Okay, let's do that. So these are what the committee, what the public protector spent on opinions.
Yes.
Correct. In the A column, each one is a different brief, and it reflects how many briefs got signed out to a particular attorney's firm. Correct?
That's correct.
And would it be fair to say by far CNEGO got the most briefs?
Yes, most of the opinions went to Mrs. CNEGO Incorporated.
Right. So let's just look at the opinions for a second as to what was done. We've dealt with the first one, which dealt with Peter Mboweni's articles. The second one was a legal opinion on crowdfunding. Can you tell us what that related to, Mr. van der Merwe?
Yes, the PP was instructed or directed to pay personal cost orders. I think it was in the CIX matter. And then the legal services were required to source a legal opinion on whether or not it was acceptable for the public protector to receive what they called crowdfunding or donations from the public and organizations to cover personal expenditures or expenditure for those for the personal cost orders. I think the personal cost order in this case amounted to about 350,000, and we spent 213,000 just to get a legal opinion to say that yes, she's entitled to get donations or to be funded from external sources for the covering of those cost orders.
From the evidence of Mr. Satoli, because I pulled it up on the summary of judgments, that the payment due was in the amount of 226,621.94 as per the court order. It was a 15% amount of the total of the tax bill. Mr. van der Merwe, I'll show the committee where that came from later. Then if you go to the next opinion.
Yeah, sorry, then it's my, I didn't know the exact amount, but yeah, 226 versus 214, 213, yes. Oh,
So
I see, sorry, it's there.
So if you look at the legal opinion in respect of the PP's employment of special advisors, this was the opinion that was obtained in respect of the employment of Mr. Niembi, correct?
Yes, that's correct, yes, in May 2018.
And then the next one is the appointment of the opinion on the employment contract of Mr. Vushi Mashlangu. Correct?
Yes, that's correct.
Which ultimately led to his resignation. Well, he subsequently resigned. Let me rephrase that.
Yeah, 2 days or so after the final legal opinion was obtained.
Right. So the final opinion comes, and according to Mr. Mashlangu's evidence, he resigned of his own accord 2 days later.
That's correct.
Then we got 2 further legal opinions that came on in request of FIC. And then we see a legal opinion on the classified IGI report. And the Ngubeni one, which we already dealt with there. We then get an opinion on the state capture matter. And then there's an opinion on the CX report, which comes in post the Constitutional Court judgment. Are you able to talk to that opinion, Mr. van der Merwe?
I know it was about not much, just whether the public protector would have been able to reopen the investigation after the report was set aside. I've read the opinion, but I haven't refreshed my memory. And I wasn't involved at the time, but I think that was the gist of it.
So after the Concord judgment, and was this during the time period in which there were some serious financial constraints at the Public Protector's Office?
Yes, absolutely.
So
it was close to R1 million.
Yeah, we see a total of about 2.2 million rand for opinions being obtained at the Public Protector's Office during this period, right? The next is dealing with the Minister of Safety and Security case. That was an adjunct in respect of the IGI report, correct?
That's correct.
Right. And so there's expenditure of 373,000. We then go to the Enquiry matter. This was a case that the Public Protector won, correct?
That's correct.
Right. And there was an expenditure of approximately 2.3 million in total.
Yes.
Right. If we go down, we see in the respect of the CR 17 matter, go down, we come to the total of approximately 4.2 million.
Yes.
Right. We then go to the DA Cassack matter. And we say approximately 3.365 million. This is only in respect of the application for leave to appeal and the proceedings that followed. Correct?
Yes, because another firm was involved in the High Court matter.
Right. Then in the next category, it appears that, does this refer to all the Gordon matters? The 36099.
Yes, it looks like it. Yeah, yeah, yeah. SARS. Yes, it's all the Gordon matters.
So stop that. That comes to approximately 16 million, 15.9 million.
Yes.
The case against Basani Baloy comes to approximately 1.9 million, correct?
Yes.
Then there was some litigation involving accountability now, which was a lesser amount for 367,000.
Yes.
Then in respect of the Commissioner of SARS, the subpoena matter, that came to 3.7 million.
Yes.
And then we come to the litigation involving the National Assembly. And I just want to point out, just go up. This fee notes start from 2020, correct?
Yes.
Right. And it comes down. And it comes to 19.6 million. Just go up again.
Yes.
Mr. Van der Merwe, this is an increase from the previous amount of 14 million that was reported because of the last invoices. Can you just explain that? It comes into the current financial year.
Yes, we've recently, there was an invoice that was delayed. We've paid so far the council fees on that. That was in respect of the impeachment matter or the Speaker of the National Assembly. And we are settling the invoice on the attorney's fees. It's a substantive invoice, so that explains the amount that was previously reported and the amount that has now been settled, and there is still an outstanding amount of about 1.7 or 1.8 million that we are currently processing on that matter.
So although the approximately 5 million is included here, and it's included the 19 million total, you've not paid that full amount as yet?
Not the full amount, yeah. The 1.1, I think it's a bit more, but the attorney's fees have not yet been settled. We are in the process of settling it now.
Right. And there's a correspondent attorney fee that's included in that amount, correct?
That's correct, yes, because we don't have someone on the panel in Cape Town.
Then there's an amount for the Madiba disciplinary hearing of 111,000. And then the next one is the criminal matter involving the public protector, correct?
That's correct.
And that comes to 672,000 approximately, right?
Yes, yes.
Okay, so of the total 55 million that you have expended on legal fees, 17 million go up. No, go back up. 17 million goes to the attorney, about 17 million goes to the junior and other, and the senior counsel bills come to close to 21 million, correct?
Yeah, that 17 million is less the amount. It includes the amount that we have not yet settled. So it's about 15 point, almost 16 million.
Yeah, and it includes disbursements and all of the figures include that.
That's great.
And by far the largest payments of well, this figures, sorry, we didn't update this figure to the previous page. Go back to firm fees. We need to fix that up. Go across. Maybe we did. Let me see. Yes, it is actually correct. We see the total council's fees as paid per other briefs in respect of a number of briefs is reflected there. And go back to Cienego's fees. Those is what gets paid out in council fees. And by far, the litigation in the Gordam matter and the National Assembly matter means Advocate Mpofu has been paid substantially more than the other council. Would that be so?
That's great. Yes.
So let's just go to the VZLR fees. I'm just going to do two of them because those are the two highest recipients of fees out of the Public Protector's Office. We see at the top that VZLR provided the legal opinion in the matter of the Pillay saga. Just go and show us I. Okay, and we see, just go back to the left. Go back, yeah, go back a bit more. Right. We see that the second matter is the Mostert matter, which we know was related to the Financial Services Board. Correct, Mr. Van der Merwe?
Yes. That's great.
And that was also a matter in which the public protector was successful in staving off the interdicts there of the investigation. Correct?
Yes, that's correct.
Right, so go down. So the Mostert matter cost 3.4 million. The matter of the next matter, which is the Financial Services Board, is the case which Ms. Mohaladi gave evidence, correct?
That's correct, yes.
And that cost approximately 6.4 million.
Yes.
Right. And if we go down, there's a matter against something called USASA. Can you offhand remember what that abbreviation stands for?
No, USASA.
It's okay, Mr.
No,
Van der
sorry,
Merwe.
not.
Yeah, even I've forgotten it now. The MCB matter is the other one, and that's currently, is that appeal still pending? You got leave to appeal this judgment, correct?
Yes.
And that was about 3 million, and then there was a legal opinions obtained during the COVID period, correct?
That's correct.
Go down. And there's a nominal amount paid out in SABs. And so we see out of the amount paid to this firm of the 14 million, it's about 5.5 million to the attorneys, 4.2 to the juniors, and 4.6 to the seniors, and by far the biggest expenditure being in respect of the Shidi matter, correct?
Yes.
I want to go just one more to the Bokwana Burns matter. Bokwana Burns is the attorneys on brief in what was the Breitenbach defamation matter, correct?
Yes. Yes.
And they replaced, sorry, just go down again. There were two, go further down. They replaced another law firm who had previously dealt with the matter. Do you see that?
Yes,
Right. So there was those costs incurred, and then we go up. Go up. And we see that the cost incurred in the defamation matter was just over 2 million rand. What has happened with that matter, Mr. Van der Merwe?
we are in the process of reviewing. I'm not sure if we've withdrawn or in the process of withdrawing. But I know the leadership will still engage the public protector on that. But there is a review of the litigation strategy in that matter because the incident occurred before the appointment of the public protector.
Yes. And is there an interest of the office in this litigation?
No, not to my knowledge.
Okay. So then if we can just go to the two law firms of Bowmans and Adams. Right. Go to fees. Right. Mr. Van der Merwe, if we scroll up on these cases, these are all cases of cost that was incurred or cost that commenced prior to the appointment of Advocate Mkhubane, correct?
That's correct, yes.
So if you go down to the total amount, these were costs that arose as a consequence of this litigation, right? The
Yes.
5.4 million in that regard. And if we go to the Adams column, which is further on, you'll see that there's a number of cases in this matter. Go up to the top. Oh, sorry. The matter of Zwani was never completed. I think Advocate Mkhubane, Mr. Sitoli's evidence was the opposition was withdrawn. Correct?
That's correct.
There was a cost order we had dealt with earlier in respect of the Van Rooyen matter. Shepherd, just go down. Right. There was the Zuma matter that was pending, which the Public Protector's Office was successful on, and as well as the SABC litigation that ensued. Right.
Yes.
Go further down, and the other matters, I think the Winston Mkoba matter, Advocate Mkhubane withdrew, and the other litigation all go down. Preceded the commencement of this litigation preceded the appointment. Correct? Let's just see if I'm go further down. Go. And some of these were pending when she came into office and opposition was withdrawn. Correct?
That's correct. Yes.
Go down to the bottom, to the total. So the bulk of the 6.3 million is not attributed to cases which Advocate Mkhubane commenced. Correct?
That's correct, yes.
Right. So let's just go further on. I just want to go to Fasken. There's the ABSA costs that we still need to deal with. And I think we've covered the costs of the litigation before this inquiry. Go further down. A little bit further on. No, go to folders further on. Further, go to the arrows to the right. All right. You see this one that says Fasken fees. All right. This was the law firm that was engaged in respect of the ABSA leave to appeal application. Correct, Mr. Van der Merwe?
Yes, that's correct.
So let's do the maths. For that, they billed the Public Protector's Office in total 2.3 million. And if we go further down, we will see who preceded them as the attorneys was a firm called Bill Mutsuning, and they billed approximately a further amount of just over, sorry, I think I don't have the latest version. A further amount of approximately just over 6 million. And then the opinion that was obtained by Senego, correct?
Yes.
Okay. And those, if we go back to the first document. Firm fees is essentially without having dealt with the firm specifically in the 2 million category. We've covered the main ones in the litigation that makes up the 133,000. Mr. Van der Merwe, the Cheadle one at 4.2 million, that is mostly the labor related matters, correct?
That's correct, yes.
And it also includes an amount that was paid in costs in respect of the CX matter.
Yes.
Okay. So if we go back to your affidavit. This essentially dealt with what was set out in paragraph 68, 69 of your affidavit. And you've already testified to the contents of paragraph 70 that you had been informed of an endeavor to invoices to be submitted for consulting work through legal services. And we've taken you through those invoices, specifically with reference to Mr. Ngubeni, you were so informed, correct?
That's correct.
Did you at the time know of the invoices to which the committee had specifically been referred?
I just heard that there was an attempt to produce these invoices or submit them through legal services, and Mr. Nemasisi had a problem with that. And I'm not sure if it, but that was just corridor talk about, at the time. That there was this panel, as I said, that was advising the public protector, and that they've tried to obtain that payment from the office for services that were not related to legal services.
Sorry. And then if we go to paragraph 72 of right. You point out to the numbers that have been withdrawn and the notices to abide that we had asked for follow-up, and you say that's an ongoing process, correct?
Yes, that's correct. After we've the committee assisted us in getting the a proper schedule, we are in a process of following up on those matters that were not opposed.
Then you also point out that there's a number of cost orders against the PPSA that to date not yet been actioned.
Yes, we found one that was where costs were awarded in our favor in 2000. The evidence leaders actually in this process alerted us to that, and we are now only in the process of recovering the monies from those cost orders.
And that was in respect of the Zuma matter, correct?
That's right, yes.
Right. And so we've already dealt with in a large part with what's contained in paragraph 74, which deals with the budgets as well, and the number of cases that have been litigious. We'll go to section F of your affidavit quickly. And just in summary, Mr. Van der Merwe, you set it out in quite a bit of detail, but if you could just in summary tell us what the position was in respect of the electronic case management system of the Public Protector's Office. Historically, there was an endeavor to do it with foreign funding, and pick up the story from there.
Yes, Advocate Madonsela, towards the end of her period, employed a business process engineer because we've been operating without a case management system. We were since about 2004. We had one on a subsystem that was not working, that was written off, and then we tried procurement processes, and we found that the major problem was that when the product was delivered, it was not within spec or specification. So Advocate Madonsela appointed a business process engineer with the view to draft the specifications for a case management system, also to review our business processes. And this then resulted in a business process document that informed and we got donor funding that was managed through GIZ, and we appointed a service provider to translate or to take the business process document and convert it into a high-level user requirements and specifications for a case management system. When Advocate Nkwebane came on board, there were concerns about the sources of these donor fundings, and the donor funding was, we were not going to be able to procure a system through donor funding. It was just for the use of service providers and resources, but that process was then stopped. We tried through procurement processes. We engaged CITA. In the end, the budget amount that was available when we tested the market, the bids exceeded the budgets by far. So we were stuck without the case management system, and then eventually in about 2017, we came across, we're part of the Ombudsman community in Broader and some of the other associations. So we were then alerted to a case management system that was developed by the Samoan Ombudsman. It was an open source system, meaning that you don't have to procure licenses and off-the-shelf systems. So we reached out to the developers, and they were prepared to assist us on a pro bono basis. But then, it was called the NHRI system. It stands for National Human Rights Institutes. I made a presentation to leadership, and they were interested, although there were concerns about the security of the system, both because the service provider would have been from the UK and the US, as well as the fact that we were going to do the development remotely, which means access to our database. And there was a request that the system and the developer be vetted by the State Security Agency, SSA. This was in October, September 2017. The SSA team met with the PPSA team met with the SSA. It was myself, the security manager, Mr. Nshunzi, Ms. Mositsi and Mr. Tubele, because there were also other issues that Mr. Nshunzi was raising with the SSA. We asked him, this is the brief, to help us to vet the system, the NHRI system, and they ended up making a proposal to assist us with the actual development of a case management system based on what they call their capacity and resources on the technical requirements, customization, and ensuring that correct security layers and requirements were implemented in the system. The SSA was to advise on the technical requirements, customize and ensure that the correct security layers were implemented, and the system would be paid for and owned by the PPSA. But SSA might have been involved in system maintenance and support. A proposal was then developed by SSA and presented to the PPSA leadership. It was called Project Promise. But when they developed the actual proposal and it was submitted, the cost, and remember, we were not able to pay 7 million for external service providers, but the cost that they quoted us at the time was approximately 50 million. They were still going to span it over a number of years, but it was still going to be a commitment of several million more than our budget per year. But then when we were reporting on the progress with the implementation of the case management system, because it was an issue that was constantly raised by the portfolio committee, and the involvement of the SSA came to the fore, the portfolio committee recorded serious concerns, and it was even in the media, about the proposed involvement of the SSA in the development of the project, and that Project Promise was then abandoned. We re-engaged the pro bono service providers for the open source NRI hub system, which resumed in 2018. We entered into an agreement for the customization and the development of the system on a pro bono basis. We were only going to pay for hosting and licenses, but then our developer, for which we were internally grateful at the time, fell ill during the COVID period, and in the end we were unable to proceed with him. In last year, we embarked on an in-house development through the secondment of a developer from SASA, not SSA, security agency, with the assistance of the CEO. And the development of the system, the person then came on board internally. We developed the specifications internally. The development was done internally, and the case management system was developed in January 22. And actually, we've now, the affidavit was drafted before that time, but we've implemented the system with effect from 1 August 2022. And we are now in the process of registering new cases and also migrating the cases from the manual systems to the new case management system. So that project has eventually been concluded, or is in the process of being concluded.
Your current CEO had previously been employed at SASA, correct?
That's right, yes. Through her interventions and contacts, we were able to get the assistance from a developer. It's not from the institution. They were gracious enough to second a knowledgeable and extremely bright person to us for the development of the system.
Then, Mr. Van der Merwe, there's a few things that's dealt with under general in your affidavit. What had come out in evidence and is this issue of whether the Public Protector's Office actually has a document classification system in place.
No, we don't.
Are the documents of the Public Protector's Office classified in accordance with the minimum information security standards?
No, No, we don't have confidential. Well, all the contents of case files are confidential by virtue of Section 7(2) of the Public Protector Act, which says that nobody might disclose it without the permission of, but there's no classification as such. We don't have a marking on top of a document saying secret, confidential, top secret.
And then in paragraph 93, you point out that your service delivery matters do not require classification, and they are by far the majority of the complaints received by the office, correct?
Yes, that's correct.
And about 70% deal with service delivery and 30% deal with GI matters of ethical or unethical behavior, procurement, elements of corruption. And
yes, that was the last.
Right, and you've been there since the first public protector.
Yes, January next year it will be 26 years.
Right. And you say the only time you came across a document in relation to which secrecy was involved in was the bank contract, which involved no classification.
Yes, that's correct.
Right. So you also point out that there was a change after the Nkandla investigation, because prior there to the Public Protector's Office had mostly bread and butter matters, and the complainant was the person in the street and not politically sensitive matters.
Yes.
Correct? All right. And you then point out that maybe you should talk to what your next two paragraphs, 96 to 97, Mr. Van der Merwe. The committee was informed that there was a culture of poor performance.
Yeah, I've alluded to it earlier that our annual report would show that there was a drastic reduction in the backlog matters, and the narrative that was put to most of the witnesses, and it was because of the culture of poor performance that was turned around. And I've made a note here of the unprecedented performance established through the think tank, the dashboards, the task team, and the new culture introduced by the public protector, which also resulted in a clean audit. And while those structures and so on might have been also contributing factors, I wanted to address this impression of a culture of poor performance, because the annual reports and our presentations to Treasury, and whenever we wanted to motivate for additional resources, clearly stated the impact of the lack of resources, the lack of training, the lack of enough resources, the increasing complexity of cases as having, and we were in fact stating that it was rendering the office unable to exercise and perform its constitutional function. So those factors cannot be left aside, and in my view, and this is an opinion matter, coming from my experience and observations in the office, that the backlog didn't just arise because of performance issues. There were factors beyond the control, and that's always been recognized. So what has happened in the performance culture was not addressing poor performance, but just making that's my observation, and it's just making people work harder than they were already working. The issue of deadlines was proposed as it's not unreasonable to put a deadline, because if you look at the matter holistically, to put a deadline to finalize a matter that's older than 42 months, and to say, but you must commit to finalizing this matter in the next 6 months, 6 weeks, is very reasonable and accurate for that delivery, but it doesn't take into account that the reason why the matter was delayed and was not because of a lack of a deadline. Am I still audible?
Yes.
A lack of a deadline or a lack of commitment. It just forced the investigators to work towards an end goal. As I said, it was a top-down approach because it was expected from investigators to escalate delays and implement investigation plans. And there's a lot of reasons why that process was not as effective as the top-down approach, where deadlines through the think tanks and through the TTs and the dashboards force people to commit, which caused a lot of stress. And in the end, it yielded the result. But as I said, the only way in which people could meet those deadlines was to work harder than what they were already working. It was not the factors that caused the matter to be delayed for 42 months didn't suddenly disappear. They were just forced to the point where they now had, if they didn't comply, there would have been consequences. And that was the source. So that is the change in my perspective that I wanted to address on the issue of performance. It's the contribution is obviously from the leadership, but also I want to emphatically say that it is not, in my view, a question, because the audits, everything else wouldn't have reflected, and our request for funding wouldn't have reflected the incapacity issues and the capacity constraints and limitations if it was just a question of poor performance.
And then
Thank you, Chair.
finally, you make the point in the last paragraph that whilst the issue arose of financial constraints in the context of an investigation in the report, there had been austerity measures, but you were not aware of a directive at the time that any investigation should not be conducted because of financial constraints. Correct?
That's correct, yes. The only, as I indicated, the only investigation that could not be finalized or was the state of capture report because of that. And you could have seen the amount of money and resources that eventually had to be expended on the finalization of that investigation. But then the investigation was completed up to a point where we were able to make findings and remedial action. There were no other investigations that were suspended because of financial constraints in the context of reports or a directive to this nature.
Mr. Van Merwe, just one last part that I couldn't find when I took you to it. Shepherd, could you just put NM17 back up on the screen? There were two issues I should probably clarify to the committee. As I fumbled around a little bit, if you go to the document that said FASCN fees, we needed to scroll down a little bit further to get, there we go. The total which I was fumbling and trying to get to the committee of the ABSA matter was 10.1 million. And furthermore, that in respect of the Reserve Bank case, taxed amount was 1.5 million, of which the PP was ordered to pay 15% personally, being an amount of 226,621. Both amounts have been paid in full by the PP and the PPSA as per the court order. Correct, Mr. Van der Merwe? That was
yes, that's the correct amount. I was under we paid 213,000 for a legal opinion to verify that the PP could
right.
recover 226,000.
Yeah, and effectively you were correct about the 350 because that was the contingent amount that was catered for prior to the actual amounts having come through on taxation.
Yes.
Yeah. Okay. And those are.
Thank you, Advocate Bauer. Mr. Van der Merwe, you can now switch on your camera.
Thank you, Chair.
Thank you. So you have just completed one part of a 4-part section, which is the leading of this evidence, to be followed by cross-examination, to be followed by questions by members, and if any, to be followed by any outstanding questions from the evidence leaders. But for today, that's where we're going to pause. And please don't go away, stay on the platform. As agreed yesterday, before we conclude, I'm going to invite the Secretary of the committee, Mr. Ngoma, to share with the members the draft program of what will happen next from today, and thereafter, after members will have commented on that program, we will go towards closing. Mr. Ngoma, please take us through.
Thank you, Chairperson. Good afternoon to you. Good afternoon to members, and good afternoon to Mr. Van der Merwe. Chairperson, the first 2 columns on the program would indicate the meeting of yesterday and today, and from tomorrow, which is the 3rd, until the 8th next week, we will be allocating those days to the public protector to prepare for cross-examination of the remaining witnesses, which is in this instance Ms. Nelisiwe Tejane, which is scheduled for Wednesday next week, and then the cross-examination of Mr. Van der Merwe, which is scheduled for Thursday and Friday next week. You will see, Chair, on the program that it's 2 days reflected there on Mr. Van der Merwe, and you would see that is to that time, those 2 days are located for the cross-examination and also for the questions by members. And then, Chairperson, that will then conclude the phase 1 of the hearings. Chair, the following week, after the 11th, would then be afforded to the public protector legal team to prepare. That will also include the week thereafter, which is the week beginning on the 21st of November, which is also to allow for the team to attend to legislation that is set for that week. And then Chair will then resume on the 28th, the phase 2 of the hearings, Monday the 28th, where the committee would then be is set to hear witnesses of the public protector. So those hearings, Chair, are set for that whole week and the following week until the 9th of December. Chairperson, we then move on to, obviously, Chair, we then allow time for the break, as it would be in December. And then, Chairperson, depending on whether we complete the hearings of the public protector witnesses by that Friday, the 9th of December. If not, we'll continue with those hearings in January. But for now, Chairperson, the committee is set to resume in January, on the 23rd of January for closing arguments, which is set for 5 days. And then the 30th of January is then the committee deliberations. And as we always do, table correspondence, review the program, adopt minutes of the committee, something that we have not done in a while. Chair, and thereafter, Chair, we anticipate that from the end of January until the first week of February, the committee support staff would then be drafting the report, which will then be deliberated on in the middle of February on 15, 16. And we expect that on the 17th of February, the committee consider and adopt a draft report, which will then be sent to the public protector for comments. We give about 20 days for her to comment on that report. Then will be considered by the committee on the 27th of March. The responses that would have been received from the public protector, and until the committee chair, as it stands, the last date where we expect that the committee should adopt its final report and table it to the National Assembly would be the 29th of March 2023. That is the draft program, Chairperson, that I present to you in this committee. Thank you very much.
Thank you, Mr. Ngoma. I'm going to invite you, honorable members, for your brief comments. If there are any suggestions about things you think must be considered for changes and so on, and your comments are only confined to the program at this stage, because you will still have an opportunity to engage with other matters. I see Honorable Paula Ngola. Honorable Gondwe. Everybody else just open the line. None. Yes, so let's share a little bit, but I'm okay. And then, thank you, Honorable Tlagode. Honorable Ngola.
Yes, thank you, Chair. Just a slight proposal in respect of the program. Can we deal with the minutes for 2022 in the last day in 2022, so that we adopt all of them before we close down for December? Then we'll adopt others as you come back.
All right. Adoption of all minutes. Thank you, Honorable Ngola. Honorable Gonde.
Thank you, Chair. Mine is more of a clarity seeking question. I didn't quite catch why we have that huge break between the 11th and the 28th of November. That's a good 17 days that we're not sitting.
Come again?
In the program, there's a break from the 11th to the 28th of November. So I didn't quite catch why we're having that huge break, because that's a good, I think, 17 days that we will not be sitting.
Okay.
So I wanted clarity on that, please.
Okay, thank you. Before I go to Honorable Tlagode, you quickly want to clarify that, Mr. Ngoma, the long break.
Thank you, Chairperson. Chairperson has indicated the PP team had requested that we afford them some time before to prepare for their witnesses, and also Chair indicating what is contained in the directive, the number of days that would afford to them. But we also, Chairperson, aware that they would also be preparing for litigation that is taking place in the week of the 21st. So that is also to afford them time to prepare for that. Hence, the committee will only be resuming on the 28th. Thank you, Chairperson.
Thank you, Mr. Ngoma. Clarified, Honorable Gonde. Follow up? Yes.
Yeah, it's a good 17 days. Do they really need all the time? Not that I'm being unreasonable, but I'm looking at the fact that time is against us. And I mean, even finishing our business in March next year, it's still cutting it too short. And we have to factor in, eventualities and the like, so that's just a concern I have, but I guess I understand.
Okay, thank you. Honorable Tlagode.
Thank you very much, Honorable Chairperson. What a long day. Honorable Chair, I want to differ with my colleague here, Honorable Gondwe, and agree with Mr. Ngoma on this program of the committee. Remember, when we first started, we were advised that we must conduct our work in a fair manner. So also taking into account that this is not the only committee that we are serving in, there are other committees of parliament. And also I believe that the evidence leaders also will have enough time
to do their other work, and the PPO will be given enough time also to prepare for her witnesses. So hence I'm supporting this proposal, and also to remind ourselves that our program is a living document, which is always flexible for anything. Thank you very much.
And thank you for reminding us of the living document. Thank you. There's no other hands. I think the issue raised, which Mr. Ngoma will take up, and then we create a slot for that, the adoption of the minutes, so that 2022 is closed properly. I think the clarity on the what seems to be a long break, maybe as we go, you will be able to see, maybe it's necessary that we're able to set that up front, but clarity sort of concern raised around that. We'll still look into that, but I think Honorable Lagude has tried to respond to that, and it's exactly those issues she is raising, but your concern is taken about that. You don't want to miss the chairperson in this committee. Otherwise, there's going to be a lull. Thank you, Honorable Gonde. Maybe before I summarize the way forward and closure, Advocate Bauer.
Mr. Chair, there is an issue that I do need to address. It has often been referred to that the evidence leader's last witness is Advocate van der Merwe. He is not our last witness. Ideally, our last witness, we would have preferred our last witness to be the public protector. And the reason for that is that you would be aware that under the directives and the rules, there are a number of affidavits that are part of the court papers, including affidavits of the public protector. We have not sought to deal with that and duplicate it in oral evidence, but there are pertinent questions that arise that we would need to put to the public protector in that course, in light of an indication that the public protector seeks to lead other evidence that would then arise in asking her those questions after those witnesses had been led. I had also in passing indicated that there are in particular the investigators that dealt with the Cordan matter. We have not called as witnesses, and they are on the public protector's list, and it may well be, depending on the evidence that we may need to subsequently, depending on how the evidence unfold, the committee may benefit from hearing from them. Very early on in the proceedings, Advocate Mpofu had indicated when he cross-examined Mr. van Lachenberg that he intended to call them. And so it must be quite clear that this is not a trial where there's a closing of a case. This is an inquiry in an inquisitorial instance in which one component of what we put before the committee has concluded, and that's the oral evidence from our side.
Thank you, Advocate Bauer. Those points taken. Just been reminded by the public protector, they would have sent an email to Thembi Nkosi. She needed to be at the airport. So don't want to keep you any longer. Colleagues, concludes our meeting today, inquiry, until we resume next week. Thank you very much. The meeting is adjourned.